Well, kia ora everybody, and welcome to the second day of these freshwater hearings. I have to start with the usual homily as to the health and safety things. Doorway out the back if we have an emergency. Assembly point outside the state sale house, and toilet facilities are at the back as well. If everybody please just check their cell phones, make sure the cell phones are off. And that's all that I have to deal with those matters. Otherwise, the batting order today is slightly changed as a result of some things that happened yesterday. So we've got to complete the evidence of Felicity Boyd, which will, I think, take about half an hour, 3/4 of an hour.
Less than that.
Right, thank you.
Well done.
But some questions from us, obviously, and potentially, although I'm not sure about that, we might reserve those, I think, till right at the end. And then I'm told that has agreed to go in the afternoon, so we, after Felicity Boyd's finished, we would then commence with Otago Water Resource Users Group. Thank you, Felicity.
I've risen to the challenge posed by Mr. Adams yesterday, and I have one page. The first topic that I have addressed in my key points here is water quantity, and I don't propose to read that out. That was really to provide some information in response to questions from Commissioner Sullivan yesterday about water quantity and over allocation. There is a lack of technical information available at the moment, but I've included some information about the current regime and what Council has agreed to include in the new land and water plan as an indication of the scale of change in that regime. So I'll skip down to the freshwater vision timeframes, and I've addressed these at length in my opening statement, but at a very high level. Ambitious but reasonable was a difficult test, and there's no case law on it. For the reasons set out in my opening statement, I generally support the existing timeframes, except that North Otago looks unlikely to be achievable given nutrient lag times. Lower Clutha may be unachievable given that there are higher or contributing catchments with longer timeframes, and the Manahira Kia is challenging, and I'm open to hearing more evidence on the timeframe for that one. In terms of wastewater discharges, Kaitahu seeks to phase out all direct discharges of wastewater to water. Others consider there should still be a pathway provided if the adverse effects of a discharge to land would be greater than a discharge to water. In addition to that question, there is an additional question about whether the same direction should apply to all discharges of wastewater or only those containing sewage and or industrial and trade waste. And finally, on natural wetlands, the planning witnesses from DOC, Kaitahu, ORC and Fish and Game have discussed an amendment to, so that's not P7, it's P9. Policy 9, clause 1, as a result of the supplementary evidence filed on the implications of the NPS IB. We're not far from reaching agreement on that amendment and propose to table it once we have confirmed that we're in agreement. The other point I'd note there, which was raised by some witnesses, was that the effects management hierarchy in the NPS for IB does not apply to renewable electricity generation activities, but the hierarchy in the NPS FM does apply to those activities if they're occurring within a natural wetland. So there's some nuance to whatever drafting is proposed in respect of those activities.
Just to the first bullet point, in terms of water quantity,
Yeah.
those figures, are you saying, can you just explain those?
Sure. So in the water plan at the moment, there are 14 catchments that have specific take limits. Tom Palsamarker's evidence on Plan Change 7 compared those existing take limits in the plan with the consented allocation which shows that 7 of the 14 catchments were either at or over the take limits set in the regional plan, including the 2 that I've listed. Manahira Kia in the plan, the take limit is listed as 3,200 litres per second, and the consented allocation at 2020 was almost 29,000 litres per second. In the entirety, the take limit is set at 4,860 litres per second. That's compared to a consented allocation of nearly 25,000 litres per second. Consented is obviously not actual use, but given the significance of those figures in comparison to what's the take limit in the plan, I'd suggest that it's unlikely that a large proportion of it is paper.
Does that include a large number of deemed permits in those catchment sites?
Yes.
So the seasonal volumes would be massive in comparison to actual use.
Yes. Yeah. It's not I'm not saying at all that this is an indication of the scale of over allocation, but I think it's an indication of the potential that there is for over allocation. And those 2 catchments in terms of their land area make up 25% of the land area in Otago.
Thank you very much for that, because it's extremely helpful material, as Gary Sullivan said yesterday. It's just a total gap otherwise.
There is some more information in my opening statement about the recent decision on the Manahira Kia minimum flows, which is the other part of your allocation regime, which is indicates a shift from 900 litres per second up to somewhere between 2,000 and 2,500 litres per second, which again indicates the magnitude of change.
Are you intending that as being the presentation this morning, with us taking as read the rest of that statement?
Yes.
Yep. Okay. Thank you. Well, through half an hour, so thank you very much for that. So we move on to Otago users.
So I'm probably an unfamiliar face to most of the panel. My name is Freshwater Hearing. I'm taking over from Phil Page, as he's currently in New York on sabbatical, but taking a well-deserved break. I think Jack is just passing around our opening legal submissions, and then we'll proceed to our witnesses after those. Perhaps just before I start, one of our witnesses, Luke Kane, has just let us know that he's unavailable to make it up today. There's something going on the farm that he can't get away from, unfortunately. If you did have questions for him, what I'd like to suggest is that perhaps put those to him in writing, and we'll respond if necessary. I am really sorry about the short notice. Apparently it's unavoidable. Right, so I'll kick off with the legal submissions. I'm happy to be interrupted if you have questions during the course of those, or obviously take questions at the end. So these submissions are obviously filed on behalf of the Water Users Group, Federated Farmers and Dairy NZ, who have been coordinating the case in relation to this regional policy statement. Submitters have filed reasonably extensive evidence addressing the particular importance of the food and fibre sector in Otago and the challenges faced by that sector in responding to an ever-changing regulatory environment. Much of this evidence has already been traversed through the non-freshwater part of the process, where the submitters sought provisions to better recognise the contribution of the sector to the region and the need to utilise resources to provide for the well-being of the community. A number of the lay witnesses have added to their evidence, specifically addressing the consultation processes that they've participated in and the work that has been done by catchment community groups in Otago. Evidence has also been filed by Kate Scott and Claire Perkins relating to planning matters, suggested provisions and providing some further context about the existing regulatory regimes in place. At paragraph 3 there, I just set out the key matters that I'll be talking through in the submission. At paragraph 4, in broad terms, the case for the submitters can be summarised as this: that the council have not engaged with communities in the development of the regional policy statement as required by the NPSFN, particularly in relation to the Otago expression of Te Mana o Te Wai and the freshwater visions. The RPS visions do not accurately reflect the values of the communities that the communities did tell the council about during the consultation process that was undertaken, resulting in visions that are substantively deficient. If the deficiencies in the visions are not corrected, those deficiencies will permeate the lower order documents that are required to give effect to this RPS. That will result in Te Mana o Te Wai and the purpose of the Resource Management Act not being achieved. However, the submitters do not want to go back to square one. Instead, they seek a suite of changes and new provisions that will provide a framework for those deficiencies to be corrected through subsequent steps in the process. These changes would facilitate and direct an ongoing engagement process with communities. I think it's useful, as Mr. Page did, to think about how we've ended up here. And I think it would be fair to say that all stakeholders in this RPS process have been operating under what would be suboptimal timeframes imposed on them by the Minister. Added to that, the vagaries of the COVID-19 response that coincided with much of the pre-notification consultation phase. And that's had consequences, I think, for the quality of the process that was able to be undertaken by the Council. The purpose of the commentary that follows is to identify for the panel the issues that the submitters say exist with the consultation process, as opposed to the engagement process that was required by the NPSFN. And as I've said, these issues suffuse the RPS and give rise to many of the matters of concern that the submitters have. So what is engagement? Development of the Otago expression of Te Mana o Te Wai and the visions requires engagement with communities and tangata whenua. It's submitted that the process followed by the ORC with the community was a process of consultation. The use of the term engagement requires something more than just consultation. It implies a deeper process, an involved one, that allows the community to really grasp the nettle. It is submitted that an engagement process would have involved circling back to the communities with draft visions and their consequences, so the community could understand the implications and adjust the visions if necessary to better achieve what they wanted. Engagement with communities and tangata whenua is central to the implementation of Te Mana o Te Wai. Clause 3.2, subclause 1 of the NPSFN compels the Council to engage on how Te Mana o Te Wai applies in Otago. Clause 3.2, subclause 2b, compels the Council to engage with communities and tangata whenua in relation to the long-term visions. Clause 3.3, subclause 3a, requires every long-term vision to be developed through engagement with communities and tangata whenua. To that end, Te Mana o Te Wai is intended to be for the community and by the community. When I refer to the community there, I mean both tangata whenua and the community in total. Engagement and consultation are not the same thing. Consultation may form part of the engagement process, but it is only one part. And it is submitted that legislators have been deliberate in using the term engage. The definitions of engage and consult highlight the difference in approach. They are not synonymous. Consult means to seek information or advice, whereas engage means participate or become involved to establish meaningful contact or connection. The Department of Prime Minister and Cabinet discusses the importance of engagement for policy development. noting that community engagement and policy making allows those who are affected by a decision or interested in an issue to be involved in policy design, development, and decision making. Community engagement can involve informing, consulting, involving, collaborating, and empowering. Don't like Community engagement is identified as being important when there are hard choices to be made and where disruption may result, or when we want to govern what people and organisations can do. In my submission, that is what we are dealing with here and why that engagement process is so important. Section 32, the Section 32 report in support of the MPSFM noted that giving effect to Te Mana o Te Wai involves engagement with tangata whenua and communities in a collaborative and informed process to identify the long-term vision, values, and desired future states. And this is made clear in clauses 1.3, 3.2 to 3.4 of the MPSFM. It is submitted that the requirement to engage was a deliberate decision, and that is because it was obvious that the consequence of implementing Te Mana o Te Wai and the vision setting process would be the need to make some hard choices with the potential for considerable disruption to some sectors or communities. Turning to the term community. It isn't a term that we see defined in the Act, the policy statement, or the national planning standards. And it is submitted that the ordinary meaning of the word is appropriate. That is, people living in one particular area or people who are considered as a unit because of their common interests, social group, or nationality. The submitters form a community as members of the same sector, but are also part of the geographical community within which they operate. It is further submitted that they are a particularly important part of the community to engage with in relation to the freshwater visions, due to the extent of disruption that they are likely to face as the visions are pursued. And that is apparent from the evidence of Mr. Cadena, Mr. Patterson, Ms. Hunter, Ms. McGimpsey, Mr. Glennie, and the farmer witnesses themselves. It is submitted that given the visions are required to be set at an FNU, part FNU, or catchment level, the community that is engaged with needs to be at that same scale. That is supported by the fact the visions must be informed by an understanding of the history and environmental pressures of the freshwater management unit or catchment. Now, my submission is important when we're interrogating the outcomes of the Council's consultation process to understand where participants are located and whether they are part of the FNU or Rohe community. The people that will be possessed of some of the best information in relation to the history and environmental pressures of a catchment will be those that live and work in the area. Those people have some of the greatest connections and are likely to be impacted most and have a commensurate role in setting the direction and methods of travel. At the end of the day, it is those same people who will need to get the job done and grapple with the hard choices that get made. So have the ORC engaged? Unfortunately, the answer is no. The Council has consulted on a subset of requirements in the MPSFM, being the values, but that is it. The evidence of Luke Kane, Logan Wallace, Emma Crutchley, Joe Hay, Claire Perkins, and Kate Scott discusses the meetings that they participated in. It is apparent from that evidence that the process provided some information about the problems that needed to be solved and sought some feedback on values. It did not seek input in relation to timeframes or options to achieve those values. There does not appear to have been discussions about the history of the catchments and how that may support or constrain the ability to achieve aspects of the visions identified. The Council did not provide information on opportunities or alternative solutions, and therefore the Council has been unable to canvass the community's views on those. Having obtained input on the values within the catchment, there has been no circling back to see whether the visions the Council's produced following their public meetings reflected what the community wanted, meant, or aspires to. This appears to be in contrast with the process undertaken with mana whenua through the Papatipu Runanga Consultancy Services. It is apparent from the evidence of those parties and the ORC, and it would appear that that process has been reasonably fruitful, albeit that universal agreement has not been reached. But of course, that is not a requirement. The NPS provisions expect engagement to have occurred with communities and tangata whenua with respect to the visions, and therefore the difference in approach is difficult to reconcile. In essence, the first opportunity that the community has had to assess whether their input into the visions has been reflected was the notification of the RPS and the formal submission process. There certainly has been no collaboration with the community within the drafting of those provisions. And given that, it is submitted that this hearing process holds particular importance. It holds importance in seeking to rectify some of the deficiencies in the process, rectifying some of the deficiencies in the substance of the provisions that have been produced, and ensuring that the provisions of the RPS do not leave room for those deficiencies to arise again as the land and water plan is developed. So turning to whether the visions reflect the community's input, the evidence filed by the submitters describes the input that was provided by the community during the consultation process that was undertaken. It is clear from the evidence that the visions that have been produced do not cover the field. The missing piece of the puzzle is typically in relation to values ascribed with resource use and the ability for water bodies to contribute to a thriving and prosperous community. These omissions appear to be a consequence of the approach that the council have chosen to take, which Ms. Boyd summarised orally during the non-freshwater hearing as protect the environment and the rest will follow. With respect, that is not what sustainable management requires and not what the Act requires of a regional policy statement. It is submitted that the evidence demonstrates that only some of the aspirations of the community have been incorporated into the visions. Those aspects that relate to natural environmental health and human use values like recreation have typically been picked up, whilst other values such as human use values associated with resource use, production and thriving communities have largely been omitted or are limited to the production of food. This means that the visions not only fail to reflect the values of the community, they also fail to fully respond to the objective of the NPSFN and give effect to Te Mana o Te Wai and achieve the purpose of the Act. Do the visions satisfy the requirements of the NPSFN? Now, unfortunately, the answer to this question is also no. Clause 3.3 expects more of visions than vague statements. It places a mandatory obligation to set goals that are ambitious but reasonable and identify timeframes for achieving those goals that are both ambitious and reasonable. There are multiple layers to the assessment required. It is widely understood that good goals need to possess the following characteristics. They need to be SMART, that is, specific, measurable, achievable, relevant, and time-bound. It is submitted the visions fall well short of this, as they lack specificity to know what needs to be measured and therefore whether they can be achieved within the specified time. With respect to the timeframes, it's apparent from the consultation material that times have simply been chosen to reflect short-term, medium-term, and long-term up to 2050. I assume this is because the government's essential freshwater package, of which the NPSFN is one part, speaks of degraded water being restored within a generation. However, there is no such direction of that in the NPSFN itself. Therefore, in my submission, there is no time constraint for achieving the visions placed upon the Council by the NPSFN. It is the NPSFN that must be given effect in this process, not the terms of wider government policy that have not been incorporated into a statutory document. Regardless, what constitutes an ambitious but reasonable endpoint in an ambitious but reasonable timeframe can only be determined through evaluation of what the visions require and how that can be achieved. Currently, the best information available to the panel is the evidence presented by the submitters, particularly that of Mr. Cadena, Patterson, Glennie, Dicey, Sheehan, Anderson, and Ms. Hunter. Council has been unable to identify where the council has undertaken the analysis required by subclause 4 of the NPSFM clause 3.3. Any distinction between the catchment timeframes appears to be based on the council's science program, dividing the catchments into 4 categories, from complex to simple. These categorizations do not appear to have anything to do with the change required within the catchment themselves, but rather a reflection of how much work the council need to do in order to understand those catchments. Further to that, the information provided by council as submitter indicates that in relation to at least some of the catchments, the visions will not be met simply by virtue of natural environmental lags associated with water quality improvements. In these circumstances, the community is being set up to fail. As a result of this, it's effectively impossible to deduce from the information available whether the visions or timeframes are ambitious but reasonable. It is entirely possible that in some cases they are too ambitious and in others not enough. So what does ambitious but and reasonable mean? And there's a difference, there's 2 requirements to test ambitious but reasonable, and one is ambitious but and one is ambitious and. I don't think it makes a lot of difference, but there's a drafting difference there. That phrase, ambitious and reasonable, is new. And clause 3.32b elaborates on it by saying that it is difficult to achieve but not impossible, or you could put it another way, hard but doable. Plain English definitions provide some further illumination. Reasonable means fair and sensible, as much as is appropriate, moderate. And synonyms include the likes of fair, realistic, practicable, and feasible. Ambitious means intended to satisfy high aspirations and therefore difficult to achieve. And synonyms include demanding, challenging, and tough. It is submitted that in being ambitious, the goals required by clause 3.3 need to be stretch goals, something that is not immediately attainable. But the requirement for them to be reasonable must also mean that they can be sustained by the community and are achievable. That must be the case if the purpose of the Act is to be served by these provisions. To be able to determine whether a vision is ambitious and reasonable, it is necessary to be able to assess what change is required, and so the methods for implementing that change can be identified and analysed. In my view, achieving the vision cannot be an exercise in hitting and hoping. We must be able to point to a solution, at least conceptually, and know that we can implement it within the required time for the visions to meet that test. If it is not the case, then the vision is ambitious and impossible, which would be inconsistent with clause 3.3, subclause 2. Now, it's apparent from the evidence of Mr. Cadena that timing is important. And this is possibly why clause 3.3 requires both the goal and the time frame to be tested for ambitiousness and reasonableness. An ambitious goal may be unreasonable if it needs to be achieved in 10 years, but reasonable if a 20-year time frame is given. So turning to how we fix it. Now, it is tempting to say the only option is to go back to the beginning and start again, but that does serve no one. Least of all the submitters, who crave nothing more than for progress to be made and for certainty moving forward. Given that, the submitters are seeking a suite of provisions that amend the visions to recognise the importance of resource use as a matter to be pursued in order to give effect to Te Mana o Te Wai and the 3 priorities. Provisions that will support an iterative process for the visions that allows for the evolution of them as further information comes to the fore. And this appears to have been intended, albeit not well articulated, in the text of the NPSFM. And then provisions that provide clear direction with respect to the methods that need to be deployed to implement the visions. Now, these changes are achieved via amendments and proposed directive provisions, process provisions set out in the evidence of Ms. Perkins. The purpose of these provisions is to provide council with clear direction about the evaluative exercise that needs to be undertaken as it engages with communities in tangata whenua on the more detailed land and water plan framework. This will plug the gaps that mean the current visions do not present as goals and enable the assessment of whether the visions are ambitious but reasonable to take place in timeframes to be tweaked if necessary. If the changes that are sought by the submitters are not incorporated, then we are left in a position of having visions set in the regional policy statement to which a subsequent plan must give effect that are in breach of the NPSFM obligations, and therefore unable to achieve the purpose of the Act. It has to be an untenable situation for everybody. Turning now to whether the RPS faithfully reflects the fundamental concept of Te Mana o Te Wai. And there is a contrast between the NPSFM and regional policy statement descriptions of Te Mana o Te Wai, and that's evident. Te Mana o Te Wai in the NPSFM is a concept that refers to water as fundamentally important to the wider environment and the community. It protects the Māori and restores the balance between water, the wider environment, and the community. In my submissions, it is a multifaceted concept that includes consideration of both use and protection. It is submitted that reducing Te Mana o Te Wai to a strict hierarchy of obligations is an oversimplification that fails to satisfy the Council's important integrated management obligations and achieve the purpose of the Act. Te Mana o Te Wai in the regional policy statement has quite a different focal point. Rather than focusing on the health of the water, there is a focus on protecting the Māori of water bodies and their health and well-being and restoring it where it is degraded. I've set out the objective there. As notified, there was no mention of the wider environment at all. I do note that in the most recent Section 42A report, there has been a recommendation to include reference to the wider environment in that objective in response to the submissions from Ōrāua and Fonterra. And that is a welcome addition. But by recommending that as a provision in subclause 4A, diminishes the central importance that health and well-being of the wider environment has in the NPSFM. In the submitter's views, these concepts are interrelated, equally important, and necessary in order to achieve integrated management. And this must be the case because the NPSFM is a resource management document and subservient to the purpose of the Act. Sustainable management requires management that enables people and communities to provide for their well-being. In order to serve the purpose of the Act, the concept of Te Mana o Te Wai cannot simply focus on one aspect of the environment, and nor can the Council. The Regional Council's functions start with integrated management of natural and physical resources. Clause 3.5 of the NPSFM recognises this, noting that local authorities need adopt an integrated approach as required by Te Mana o Te Wai. Clause 3.51 prescribes the matters that must be addressed, including the interconnectedness of the whole environment, the interactions between freshwater and land, for example, the management of freshwater and land use and development, and to coordinate and sequence regional and urban growth. myself off. It's abundantly clear that the MPSFM does not anticipate a protect the water and the rest will follow approach. It requires integrated management across all matters. Te mana o te wai requires the same if we are to restore the balance between water, the wider environment, and the community. The fundamental concept does not refer to restoring the health of water alone. It is submitted that restoration is also intended to be integrated, taking into account the range of factors that need to be managed and protected. Like it or not, there's a certain circularity or interreliance to the concept, and that was confirmed by in the Section 32 report in support of the NPSFM, which notes the assessment of efficiency draws on the base assumption that the concept of te mana o te wai focuses on ensuring, and in some instances restoring, the balance between health and well-being of water bodies and freshwater ecosystems, the health needs of people and other communities, and other community needs informed by a hierarchy of obligations. It is a multifaceted concept that includes consideration of both use and protection values and outcomes. The philosophical approach taken by the regional policy statement does not reflect the purpose of the Act, the concept of integrated management, or the nature of te mana o te wai. And this matter was also traversed by my colleague Mr. Page in his opening submissions on the non-freshwater part, and I refer you back to the key paragraphs there. The use of restored in the regional policy statement also creates uncertainty as to the point in time that restoration is required to, and ignores some of the irreversible changes that have occurred, such as the introduction of pest species or the establishment of significant infrastructure that alters the hydrological functioning of some catchments. In contrast, restoring in the NPSFM is about the balance between water, the wider environment, and the community. It is submitted that balance is not an absolute concept, but a policy one, a matter for the community as a whole. Hence the obligation to engage with the community and tangata whenua in determining how te mana o te wai will be given effect and to set the visions. The point I suppose I'm trying to make there is that where health and well-being of the water is going to sit on a continuum. It's an ecological system ultimately at the end of the day. And the decision that needs to be made is where on that continuum do we say that health and well-being of the water body has been appropriately provided for. And in my submission, that is a policy decision and one that needs to be determined through that engagement process with communities. And that is how we'll understand where the balance sits between water, the wider environment, and the community. The Section 32 evaluation report does not reflect any engagement with community with respect to LFY01 at all. On the face of it, the Council have not engaged with the community on the Otago expression of te mana o te wai at all. Turning to the place of Māori, the regional policy objective contains a subtle but significant difference from the NPS in relation to Māori. In the NPS, the protection of Māori is an outcome. In the PRPS, it is the objective. It is submitted that this creates a number of challenges in applying and understanding the implications of the regional policy statement framework. Firstly, Māori is not defined. In the context of the national policy statement, the term appears twice. and fundamental concept as an outcome of Te Mana o Te Wai and in respect of the compulsory main kai value in Appendix 1A. In effect, it's my submission, the MPSFN sets out through the national bottom lines things that result in Māori being achieved. And ultimately, these are biophysical criteria. In the regional policy statement, there are many references to Māori. The different contexts result in the potential for a range of interpretations. Throughout the significant resource management issues section, Māori appears to be synonymous with life supporting capacity. And I just note that in the partially operative regional policy statement, Māori did have a definition. And that definition I've included at footnote 19, which was effectively life supporting capacity. Did note the definition didn't replicate the term Māori, but achieved its essence. We don't have that direction or assistance in the proposed regional policy statement. Through the environmental management perspectives and values of Kaitahu section, there is a spiritual dimension introduced relating more to a metaphysical life force, as opposed to biophysical life supporting capacity. And this metaphysical element does not appear to have ascribed to it criteria that can be measured. There are no standards set to allow communities to assess whether Māori as a metaphysical concept is provided for. And the structure of the NPS provision means that if the health and well-being of the water body is achieved, then Māori follows. The change in the RPS provision opens the door to the metaphysical matters being the arbiter, because if it is not captured in the health and well-being of the water body, then it must mean something different. The regional policy statement says that Māori can only be defined by mana whenua, and therefore the current drafting has the potential of laying the obligation to determine whether Te Mana o Te Wai is achieved at the feet of mana whenua. Now, it is submitted that this would be inconsistent with clause 3.2 subclause 1 of the NPSFN. It would also be inconsistent with the court's conclusions in Ara Tiatia that Te Mana o Te Wai is a water-centric concept that benefits all New Zealanders. The Environment Court's decision in Ara Tiatia also assists with respect to the place of Māori within the concept of Te Mana o Te Wai. Whilst the comments of the court were in relation to the 2014 NPSFN, the structure of Te Mana o Te Wai remains fundamentally the same. And the court noted in that case that by upholding Te Mana o Te Wai, the Māori of the water is acknowledged and protected. There are also unique challenges created if Māori is to import a metaphysical element absent biophysical aspects. The RMA is concerned with management of natural and physical resources. Therefore, biophysical effects are necessary in order for any metaphysical effects to arise. This requirement enables objective, measurable parameters to be relied upon to determine effects and for parties to be able to provide probative evidence to support their views. This evidence can, of course, include the application of mataranga. But to put it another way, if an activity does not give rise to adverse effects on the physical environment, it is difficult to see how adverse effects arise in the metaphysical sphere. And I think listening to the evidence from Kaitahu representatives yesterday, I don't think there's a wild difference here in what we're trying to achieve. I think Ms. Cook's explanation of what you see, what you feel, what you smell, those things I think can be ascribed measurable parameters, that if we can achieve those, we understand that those qualities, those sensory experiences are achieved. But I think we need to be able to have that aspect covered off so that people that cannot express Māori because they are not mana whenua can understand whether they have achieved that element and assess that using measurable criteria. Turning now to whether a region-wide objective or vision is lawful. The Section 42 report has made some significant amendments to the freshwater visions, condensing common themes from the individual freshwater visions into one freshwater objective for the region. Now, my submission, that approach is unlawful. The NPSFM is clear that freshwater visions must be set, and they may be set at an FMU, party FMU or catchment level. Clause 3.3 subclause 2 does not provide for a region-wide vision to be set. And this interpretation is consistent with the Ministry for the Environment's guidance, which specifically notes that a region-wide vision cannot be set. Therefore, the provision promoted in the Section 42A report cannot be a vision. And so only those parts that remain applicable to the individual FMUs or ROHEs can form part of the visions. And clearly, that would result in substantively deficient visions. Having one region-wide provision clearly runs contrary to the intention of the NPSFM. A region-wide vision cannot account for the specific environmental pressures and histories that exist within the various FMUs and ROHE. It is likely to lead to the identification of extremely coarse freshwater limits that equally do not take account of the complexity and nuance within different catchments. And it does not allow for an appropriate assessment of what is ambitious but reasonable within a catchment. So a single region-wide objective risks undermining the framework that follows from the NPSFM visions. For example, certified freshwater farm plans. Now, these plans require reference to a catchment context, which will almost certainly include incorporation or reference to the visions. To have meaning within a catchment context, the visions need to be set at an appropriate scale. It is submitted that the change must be abandoned and comprehensive FMU and catchment visions need to be reinstated in order for the regional policy statement to give effect to the NPSFM. I'd just like to add there, I think from what I can gather, one of the reasons for trying to distill common themes down into one objective is to respond to inconsistencies in the way that some of the visions were expressed. Now, those visions are meant to be a result of engagement, or in this case, a result of consultation. Now, it's entirely possible, and I think probable, that those individual communities had slightly different expectations or desires with respect to some of the elements of their visions. And so I don't think it's necessary for all of the visions to use exactly the same phraseology because they need to reflect what the community wanted. So where there were drafting changes, there might have been a good reason for that. It might have been because that's what the community asked for. So I think, you know, if that region-wide objective or provision is to remain, it's not a vision. And so then if it's going to remain sitting there, you have to ask yourself, what function is it serving? How does it dovetail with the individual catchment visions? And I think there's a real risk of creating inconsistency or complexity between an overarching region-wide vision and what the community has articulated it aspires to at a FMU or catchment level. And so in my view, it's really important that those visions are articulated at that catchment level, so that as we respond to those through the land and water planning process, we can give those visions their catchment flavour. And that may mean that if you were to use the same terminology, the outcome for an individual catchment in terms of its management regime, possibly some of the standards that need to be achieved within timeframes, might vary from catchment to catchment, because the catchments are different. They have different histories, they have different environmental pressures. And I think a region-wide objective has a real potential to cut across that process and create an extra layer of complexity or confusion that isn't going to assist either the council or the communities in understanding where they need to get to. Next, I would like to just respond to some of the matters raised in the rebuttal evidence of Mr. Farrell, particularly the part of his evidence addressing Te Mana o Te Wai and the freshwater priorities. His evidence strays into matters of statutory interpretation that are worthy of comment. Firstly, Mr. Farrell's position relies on Māori being prioritised in the objective of the NPSFM. And that is not how the objective is articulated and not how the fundamental concept of Te Mana o Te Wai is expressed. The fundamental concept seeks to ensure that the health and well-being of water is protected, and in doing so Māori is protected. It is a consequence of achieving the health and well-being of water bodies. As I've said, that's consistent with the court's findings in Aratiatia, that Te Mana o Te Wai is a water-centric concept. This finding goes against Mr. Farrell's assertion that the NPSFM has orchestrated a paradigm shift between Western and Eastern paradigms. The NPSFM is a creature of the Resource Management Act. The Act's purpose remains unchanged and is agnostic to cultural paradigms. It continues to require management of the environment and provision for people to achieve their well-beings. I think just to elaborate on that point, I don't think reducing Te Mana o Te Wai to paradigms assists the community in grappling with that issue. I think there is space in the conversation, in the processes that follow, for all of those perspectives to be brought together. And I think that's really important if we are to get the community as a whole, tangata whenua and the community, to work together to identify the changes that need to be made, how we implement those, and how we do that in a way that sustains the current community and future generations. Mr. Farrell's strict interpretation of the priority regime ignores the complexity of the fundamental concept of Te Mana o Te Wai, which seeks to restore the balance between water, the wider environment, and the community. In my submission, the fundamental concept implies a reciprocity between its various facets, rather than a strict hierarchy. This was articulated in the Section 32 report for the NPSFM, which stated that the objective does this by prioritising freshwater health and wellbeing, rather than seeking a desired state, such as maintenance, enhancement, or protection. To some, this would appear a departure from the common policy approach. To others, it will be a welcome foundation to support complex discussions with communities. As a single NPSFM objective, it carries a lot of responsibility and weighting. However, the Resource Management Act is not a no effects statute. It manages effects and activities. Clear health and wellbeing outcomes across the biophysical, human health, and social, economic, and cultural dimensions are sharply focused on prioritising competing interests, which may constrain growth, which allows flexibility in keeping with the effects-based regime of the Resource Management Act. This does not anticipate a blunt or strict prioritisation, which could be misdirected in achieving sustainable management. This position has more recently been confirmed by the government in discussing the amendments to the wetland definitions, where the Section 32 report stated, the intent of the NPS-FM objective is not that the first priority be read as a bottom line with the goal of achieving a pristine or pre-human water quality state. Rather, it is to shift the way we think about managing freshwater and guide the implementation of the NOF process prescribed in the NPS-FM Clause 9. The NPS-FM objective is clear in what it prioritises, but is flexible in its approach, which is consistent with the Resource Management Act, a fixed-based approach to sustainable management. Mr. Farrell's approach to Tier 2 matters demonstrates the problems created by strict interpretation. If his rationale is applied, then food produced in water, such as aquaculture, is afforded a higher status than land-based food production. On Mr. Farrell's interpretation, it is difficult to see how the health of people can actually be provided for. In effect, it would see our communities hydrated, but starving and unsanitary. And that characterisation might seem a little flippant. I don't mean it to be flippant, but it does highlight the fact that in a modern society, it is almost impossible to draw stark lines between the services and sectors that we need to create a healthy and well-functioning society. The fundamental concept of te mana o te wai acknowledges this in seeking to restore balance between water, the wider environment, and the community. It is against that background that the objective and priority regime need to be interpreted. If not, it is submitted the purpose of the Act is undermined. In paragraph 48, Mr. Farrell suggests the RPS directs that MODI and the health and wellbeing of water bodies are prioritised over the costs to the current and next generation. And I don't know where the basis for that assertion exists. It does not reflect the purpose of the Act, which requires enablement of people and communities to provide for their social, economic and cultural well-being, whilst sustaining the potential for future generations to do the same. The purpose of the Act does not say undermine the social, economic and cultural well-being of current generations for the benefit of future generations. And I appreciate the purpose of the Act requires us to manage resources in a way that is all things to all people in all generations. But that is the task. It is submitted that this obligation is recognised in the NPS-FM through the process required to set the freshwater visions. The obligation for those to have regard to history and environmental pressures, to set goals that are ambitious but reasonable, is another way of saying the visions must support the current generation while also enabling the future generations to do the same. To do as Mr. Farrell would suggest will surely fail a Section 32 analysis. So turning to the National Policy Statement for Indigenous Biodiversity. And firstly, I just note that I don't have any substantive quibble with Ms. Sefton's submissions regarding your legal obligations and the framework that you have to work with in responding to that newly operative policy statement. However, there are a number of issues that arise from Ms. Boyd's proposed changes, the genesis of which are legal interpretation matters. And I note that Ms. Boyd's supplementary evidence concludes that the regional policy statement gives effect to the NPSIB, and that was the question that needed addressing. However, the supplementary evidence has gone on to discuss a different matter arising from an alleged gap between the NPSF, created by the NPS-FM definition of natural inland wetlands. Ms. Boyd identifies what she considers a gap in the NPSs created by that definition, which is also relied upon in the Indigenous Biodiversity NPS. Ms. Boyd appears to second guess the wisdom of the 2023 amendments to the natural inland wetland definition in the NPS-FM. And with respect, that's going beyond the brief. In essence, the supplementary evidence is suggesting that the provisions are not implementing the objective of the NPSIB or the NPS-FM. Be that as it may, what is required is to give effect to those documents as they are, not how we might wish them to be. At paragraph 69, Ms. Boyd discusses the application of the NPSIB clause 3.21 and expresses concern about how it operates in light of the pasture exclusion requirement in the natural inland wetland definition. She expresses a concern that the objectives of the NPSs cannot be achieved if only natural inland wetlands are managed by the provisions. Now, the provisions of the NPSIB and NPSFM need to be interpreted and applied in a manner that achieves their purpose and it maintains the integrity and consistency of those documents. The definitions and provisions particularise what is required in order to achieve the objectives with an increasing level of specificity. It is noted that the government elected not to amend the policies applicable to wetlands when it amended the natural inland wetlands definition. This must be on the basis that it concluded that the amended definition continued to achieve the desired outcome and implement the objectives and policies to the extent required. The Section 32 report in support of the amended definitions noted that the pasture exclusion part of the definition is intended to exclude highly modified wetland landscapes now utilised for pasture from the regulations, so they can continue to be used for pastoral purposes. It is submitted that the pasture exclusion is a demarcation between where an area is considered worthy of protection. Essentially, a threshold where the pendulum swings away from requiring protection and towards other uses. This approach is perhaps a demonstration of how to manage in accordance with the hierarchy of obligations. Therefore, the NPSIB clause 3.21 is directed at those wetlands that are sitting just above the 50% threshold as opposed to those below that threshold. It is worthy of noting that the amendments to the definition of natural inland wetland were made by the government as a result of extensive work to address issues that arose with the original definition. Ms. Hunter traverses this in her supplementary evidence. It's clear that the intent of the changes is that wetlands with more than 50% pasture are not captured by either framework, except where highly mobile fauna areas are identified. And including them is not necessary to give effect to either national policy statement. Now, the NPSFM applies to all freshwater, including groundwater, and is applicable to wetlands. In contrast, the NPSIB applies to terrestrial environments, excluding land covered by water. And so generally, it does not apply to wetlands, although there are some exceptions in respect of specified mobile fauna, promoting and restoring Indigenous vegetation cover in natural inland wetlands, where there's regional biodiversity strategies and significant natural areas containing a natural inland wetland. The only situations where the policy regime may allow for the application of the NPSIB to the natural wetland definition Ms. Boyd has put forward would be with respect to highly mobile fauna and regional biodiversity strategies. Biodiversity strategies discussed at clause 3.23 of the NPSIB. The development requires collaboration between a range of stakeholders, and there's 10 years provided to undertake that process. This is not that forum. With respect to the specified highly mobile fauna, these are covered by the NPSIB, whether or not they use areas outside terrestrial environments for part of their life cycle. Highly mobile fauna areas need to be outside of a significant natural area, and they need to be identified through clause 3.20 of the NPSIB. Policy 15 directs that areas outside SNAs that support mobile fauna are identified and managed to maintain populations. The areas that support these highly mobile faunae must be clearly identified before they are managed to maintain populations. Some wetland areas beyond those that qualify as natural inland wetlands could be identified as areas for highly mobile fauna. However, the NPS-IB does not require or anticipate blanket protection for all wetlands for this purpose. In fact, the contrary appears to have been deliberately required through a robust identification process. In my submission, there's no scope in the NPS-IB to manage adverse effects of an activity on Indigenous biodiversity in the context of a wetland, unless the wetland is identified as a specified highly mobile fauna area in accordance with clause 3.20, or it's a natural inland wetland as defined, in which case the provisions I highlighted earlier apply. In my submission, Ms. Boyd's recommendations go beyond the intended scope of the NPS-IB and the NPS-FM, I note, seeking to protect a broader class of wetlands. At paragraph 94, I've just set out for you there the identification process for highly mobile fauna areas, which is a reasonably involved process. The regime does not provide for the protection or restoration of those fauna areas, and nor does it specifically carve out natural wetlands. It was merely a regime to manage adverse effects on those areas and maintain viable populations of the specified fauna. In my submission, the approach taken by Ms. Boyd constitutes an overreach in direct contravention of the deliberate changes to the NPS-FM definition of natural inland wetland. If the NPS-IB was intended to apply to wetlands generally, it would have said so. On the contrary, it explicitly states it does not apply to water bodies in freshwater ecosystems except in specified circumstances, and those relate only to natural inland wetlands within SNAs and areas identified for highly mobile fauna. In these circumstances, the NPS-FM prevails, and I draw your attention to the relationship with other national directions in the NPS-IB, which requires the NPS-FM to prevail in the event of conflict. As you know, the Council must give effect to the provisions of the NPS-FM, which only refers to natural inland wetlands. And the NPS-FM approach is summarised succinctly at Policy 6, which says there's no further loss of extent of natural inland wetlands, their values are protected and their restoration is promoted. The natural consequence of that is that the definition of natural wetland and the policy regime for their protection that follows must be removed from the regional policy statement. In my submission, the national direction is clear and the ORC must give effect to it. So that is all from me in writing. I'll respond to any questions if you have them.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman. That was a lot to take in. So just give me a moment to get back to the start of that. Why is it not working? Yes. I think so, yeah. Let's go. This is green too. I might just have to charge on without the assistance, and some people tell me I'm too loud as it is. Mr. Irving, just when you discuss that engagement process and what may come out of that, and there's a suggestion that what the community says automatically goes into those visions. Or are you suggesting that or not? And the reason I ask that is in some contexts, in some catchments, for example, the community there may have this vision that they want various things to carry on. But perhaps the science might be telling us that, well, those type of land uses probably shouldn't occur there. How do we reflect that? Because at the end of the day, isn't it the council that's going to have to articulate those visions, taking into quite a wide range of values or visions from different parts of the community?
Yeah, I think that's right. I mean, I think to my mind, the visions need to cover the field, I suppose, and that is responding to the full suite of priorities and the objective, and all of the elements, I suppose, of sustainable management. That doesn't mean that if the community says, for example, I'll use an extreme example because it's often easier, we want to continue to discharge untreated sewage to water bodies, that would be acceptable. I think that the visions still need to operate within Te Mana o Te Wai and that hierarchy of obligations, but they do need to cover that full range of responses or uses that the community has within that priority regime or in order to achieve sustainable management. So it's, like I say, I think it's about the visions endeavouring to identify where on the continuum we land in order to meet those three priorities.
Yeah, I guess on that continuum, there's going to be groups that are going to have, one's going to have it there, one's going to have it there, one's going to want it there. So at the end of the day, the council is going to have to try and bring that together somehow.
Yeah, and I think that's right. I think that the bringing together in a way is likely to come at that NOF process in terms of where do we land in terms of the quality standards that need to be achieved and so on. But that doesn't mean that the things that community want, say for example, a thriving and prosperous community, don't get put into the visions, because that might create a tension with say health and well-being.
And we did discuss it a little yesterday about, I think Ms. Perkins raises it in her evidence about that flow through your objectives, policies, and then into those lower order documents. What you're saying, as I understand it, your farmer witnesses, that it needs to be, it's not recognised, it needs to be recognised for us to deal with it at a later point. But yeah, I guess it's how we do that. And I'm not sure if you heard Mr. Anderson's opening yesterday, given we were probably offline for a little bit. He suggested that the timeframe approach in Ms. Perkins' evidence was ultra vires, and you haven't touched on that. Yeah, I just wanted to hear a comment on that.
Yeah, I think there's two ways of responding to that. My understanding of Mr. Anderson's position was that a land and water plan couldn't essentially overrule a regional policy statement, so the time frame in the land and water plan couldn't be different. I don't think that is quite right. If the regional policy statement included in it a provision that says you can use this process in order to amend this time frame, and then if you use that process, the time frame is amended, and because you're consistent with that provision of the regional policy statement and providing a process for amendment through the land and water plan. So I think you can overcome it that way. Alternatively, the regional policy statement can anticipate that if through the land and water plan process it's identified that the visions are too ambitious or unreasonable or whatever, then an amendment to the RPS can be progressed alongside the land and water plan itself. And so you do those processes in parallel. And I think you could draft a provision that would support that approach. Interestingly, when you look at the NPS provision in relation to action plans, one of the things that that provision anticipates is action plans making recommendations about amendments to the regional policy statement and the visions. And so when you sort of read your way from start to finish of the NPS process, it does seem to me that there is this sort of iterative exercise anticipated where as we move our way through, we gain a better understanding, we learn more, we have access to better information, that these provisions will evolve and potentially change in response to that. And my last point on that, I think, would be that if we don't have a mechanism articulated in the RPS to enable that evolution, I think we start to run contrary to the obligation to use the best available information, because we may find ourselves in a position where we now understand the change necessary. That is change that's going to, say, require 40 years, let's say, but we can't implement that because our RPS vision says we've got to achieve the change in 20 years. So I think having that mechanism and that process identified and provided for in the RPS would be a really useful tool to help facilitate the process as we get into the detail down the track.
It certainly sounds pragmatic. Anyway,
I mean, I think in a perfect world, magical place, you would progress the visions alongside the land and water plan. The absence of detail and understanding that we find ourselves working with through this process makes it really hard for you as decision makers, really hard for communities to understand the visions and what they mean for them. But we don't operate in a perfect world at the moment, and I suppose I'd like to preserve the opportunity to be able to get there through those subsequent processes.
Yeah, we have been discussing how this particular policy statement does tend to create some challenges to the normal planning process and how it works through these documents. I'm just turning now to your comments around Murray. And you say in the NPS that the protection of that is an outcome, whereas in the RPS it's an objective. In general sort of planning parlance, an objective has always been kind of considered an outcome. What is the difference here between those two approaches that you're suggesting?
Yeah, I think, it's a subtle difference. But when I read the fundamental concept, it seems to me the wording is quite deliberate. We protect the health and well-being of the water body, and in doing that, Māori is protected. The RPS kind of flips that on its head, and it says protect the Māori first. So that's the sort of the thing we've got to do. And I think for parts of the community, that is a difficult concept to grasp. And I think we talked about it a little bit yesterday. I think if we look at the national bottom lines and the criteria that need to be set, they are for the most part using biophysical criteria, scientific measures. And if we can meet those, then all of the things that the likes of Ms. Cook described should be achieved. I think that is I suppose, an easier road for the community perhaps to follow. And I think it takes us ultimately to the same place. But it removes the potential, I suppose, for angst about what it is that we're trying to achieve, whether we understand it and can measure it. And I think that is helpful to focus on what we really need to focus on, which is how do we improve water quality and achieve all of the quality, the sort of narrative qualities, I suppose, that the likes of Ms. Cook articulated.
To be fair to the Kaitahi witnesses, they did indicate that really the indicators are biophysical. I think Ms. Cook referred to being a pastor in a church and believing in God. We can't legislate that.
No.
So that sort of, well, Rose probably best to talk about that. So the creation story part of that, I don't think they were asking for that to be in there. It is a biophysical measure. And that was the concern that I put to some. It is the angst we're feeling about, well, how do we determine this? Because only one group can determine that. And some of the questions were asked Mr. Cameron, and I used the word veto, which he didn't like. But the way the framework is set up, as you noted in your submissions, that it does give that impression that if I had my, and it's a question I have, if I had my planners hat, I had to assess something. It suggests to me, and I'm wanting your opinion on this and how it's set up, that if Kaitahi said, no, the Maori here is not being adequately protected, you would go no further as an assessment, because that seems to be where it stops.
Yeah, I think.
And that's the angst I hear from.
Yeah, and I think practically, if the challenge, of course, or an applicant faces is in being able to provide evidence of whether MODI is being achieved. And currently, the council would require that is a matter that is determined by mana whenua, and that is entirely appropriate. But it means then that that is the only place we can go to get that analysis done. And the criteria for analysing it currently are, it's a little bit like catching a cloud. Whereas if the provision is provide for the health and well-being of the water body, and then we've got in our land and water plan a set of the criteria, then you can work through that and then be able to go, well, we've done all of those things, and as a result of that, MODI is protected. So there's a clearer pathway for that analysis. I think that there is obviously a place for, in the criteria, the likes of the cultural health indicators that we've seen developed. And those, in my experience, have been really useful tools in assessing and I suppose putting a mataranga lens over that scientific analysis. So I think there's room for that approach in assessing the health and well-being of water bodies, but there needs to be that, I suppose, that yardstick set up in the process to help facilitate that assessment.
Just one more then before I hand over. The region-wide objective, and you're saying, I don't quite read it that it says it doesn't, in the words in the NPS, but you've relied on the section 32 saying it cannot be set that way. Generally, we're telling planners to be pragmatic and brief and don't repeat stuff. Is your issue with it that it is region wide and there's a legality issue, but is the concern more that it's not specific enough? It's not going to pick up that finer detail for each catchment, and if so, have we got enough in evidence to suggest that we can actually pick up that finer grained issue catchment by catchment, given the concern you raised around the engagement process? Because otherwise, there is a lack of information in this whole process, and that's not necessarily the council's fault. It's getting my head around how we deal with that problem in any sort of sensible way.
Yeah, I think one of my concerns with the region-wide objective is that when we come to the land and water plan, there will be standards set to achieve the criteria in that region-wide objective, and they will be the same for the entire region. Now, I think we do have enough evidence about the differences in catchments, some of the complexities across catchments, the histories that have led us to where we are now, and the difficulties, I suppose, and some of the changes that will need to be required or that will need to be facilitated or possibly won't be able to be facilitated. And as a result of that, it seems to me entirely probable that different catchments will have different standards that need to be set for the same kind of criteria.
Yeah.
And that becomes clouded, or we risk missing that nuance if there is just one blanket region-wide objective, rather than the FMU or ROHE standards, and then you follow and set provision or set standards and criteria for those individual FMUs and ROHE to follow. Equally, when we look at the way that these provisions will cascade down into the likes of freshwater farm plans, which require consideration to be given to the catchment context, I think it will be easier for people on the ground to be able to go to their catchment vision and then to cascade that down through the provision. So whilst I think there might be a degree of repetition within the individual catchment, I think when it comes to actually implementing those visions and having them cascade down through the various processes and methods to follow, it will be simpler and easier for the people that have to implement those visions if they are packaged in a way that's consistent with the catchment or the FMU that they're working with. I don't like it. In some ways, you think, well, it's splitting years here, but I think that NPS, to me, is very much driving at trying to manage those catchment units or those FMU units. The switch to a region-wide objective, I think, has the potential of clouding that quite clear direction. I think it raises questions about, are the provisions in that objective part of the visions, or is it something different? And I don't think it is helpful. We want people actually focused on the things they need to be doing within their catchment to achieve those visions, not arguing about whether that's part of the vision, not part of the vision, or whatever.
when I look at one of the new objectives for the natural character, including form and function of water bodies, it's possibly not new, but it's in the region-wide, it reflects the natural behaviours to the greatest extent practical. The evidence of the engineering witnesses that we're not going to hear from us possibly should have actually to hear on how that would be nuanced in each catchment, because I see that's one where things will be different on catchments. Maybe the planning witnesses can deal with something like that, because they are all very general, and I'm thinking what you said about what we know about catchments when we come to go through that other process. Surely there will be the ability then to, what that means there will be different in each catchment, and that's where it'll be expressed. I think maybe that's what Felicity's suggesting through the next process.
I suppose that my response to that possibly would be that by condensing it into the one objective, you send a message that the outcome needs to be the same.
Yeah.
And that's, I think, the risk of that approach. Whereas if you package it up relating to its own catchment, you've then got a set of or vision that is unique to that catchment, and that uniqueness then follows through the other documents. Otherwise, I think we will see arguments being run that where it's a region-wide objective, the intention is to achieve the same outcome across the region.
Yeah, the concern I have is what if we're of a mind to follow that, but I'm not sure how we would do it, because I don't think I've seen evidence that would say, well, this is what that particular one should look like in each catchment. I don't think we have that specific evidence.
Yeah, I don't think, I mean, there were, if you go back to what was notified, there were subtle differences in the drafting. I don't necessarily know what the justification has been for moving away from some of those differences, whether that's, that what was originally went in there was a consequence of the discussions that were had with the community, and that's why there were some differences. I don't think that if you were to essentially separate out the region-wide objective into effing your catchment objectives and use the same terminology, I don't think that creates the same problem as one condensed objective that applies across the region that I've expressed. Because I think what then happens is that we then get to have a clearer pathway from the catchment or FMU provision through into the lower order documents, and that can be expressed and fleshed out in different ways without having an implied effect on that same provision for other catchments.
Okay, thank you for that.
The green one as well.
It's too long.
Kia ora, Mr. Ling, and thank you very much for your presentation. But it does highlight yet again, I think, the divide between a couple of different ways of looking at the world. When I refer to Mātauranga Māori and science, for example, and which I've always hoped would be a harmonious marriage. But there are still some bumps in that marriage, I think, at the moment, and understandably. And one of them is the one you highlighted, which I think has had me concerned a wee bit as well. And that is defining Māori. You know, is there a definition? Is there something that, or is there a common understanding of what Māori is and how it, and I'm slowly coming to the view that there might be a smell test. You know, after our conversation yesterday from Evan Cook, you know, if it smells right, if it tastes right, blah, blah, blah. And maybe there are some snippets there that the system, and I say, you know, the political system might want to sort of consider. And starting with, okay, there's a smell test underpinning here that might usefully be better enunciated and explained in scientific terms. I'm not quite sure. I'm struggling a bit here, but because it seems to me that until we get that happy marriage or understanding, we'll forever be asking the questions that you've just raised. And it's a legitimate question. I'm not saying it's not the right question to ask. And because, I mean, Commissioner Cubitt raised this yesterday about is defining Modi the need has is that only to be done in a Māori context? You know? And particularly given that the Manawatu was not something that was initiated by Māori kind of stuff. So that, you know, the sort of, I think the tumbleweed just keeps tumbling. That sort of stuff. So I'm not criticizing or asking for an answer to any particular question, but just making the continued observation that this is one of the areas that still requires further definition, I suppose, or clarification, I suppose. That's probably the right word. But it does touch, though, on the words that you used in your presentation around biophysical and metaphysical, you know. And I suppose I would say there's no reason why the two don't exist side by side. You know, I think we just assume sometimes that they are different, and so they've got to be treated different. Whereas I think the arguments now are more about how do you make them sound the same and look the same. And I think that's one of the challenges here. I don't really have any other questions because Mr. Cubitt asked the questions that I was really after, both on Modi and on the vision thing. You know, because I suppose I kind of have a sense that there's some value in having a single vision, you know, but at the same time, as you rightly point out, there'll be those who will forever say, well, no, I want my little bit here and I want that highlighted, and that's the bit that interests me. So there's a tension there that I think the Modi issue that will still require a lot more teasing out, a whole lot more clarification. But having said that, thanks very much for your presentation.
Yeah, thanks. Most of my points have been covered off, but I just had a couple of questions. In relation to your paragraph 1, where you're talking about engagement and saying that the council's consulted on a subset of the requirements in the NQCFM being the values. So I presume, are you referring to the values in Appendix 1A and B in the NQCFM, or?
No, more I suppose the catchment, like what the people want from the catchment vision.
Right, so it's more values to
inform
the vision.
Yeah.
Okay. No, I was just a bit unsure about. I was also just turning to paragraph 36. And where you're referring to clause 4 in Yeah, and 3.3, where every council must assess whether the vision whether each venue can provide this long-term vision. I'm assuming that your submission is that should be done as part of the vision setting process and not later through the land and water plan.
Well, yes, to me, that is what the long-term vision provision requires. You've got to understand whether the vision is ambitious but reasonable as part of the vision setting exercise, which is an RPS exercise. I would agree with, I think, Mr. Anderson pointing you back to, you also need to work with the information you've got. And you're in an enviable position. I won't deny that, because I think there is quite a lack of information about, where do these visions require us to go, and therefore what can we do to meet them, and how are we going to change in order to get there, to undertake that assessment of ambitious but reasonable. But I think you do have access to some information. You've got the likes of the information produced by Mr. Dyer for the ORC's submitter, which identifies some challenges. You've got information that farming submitters have presented around the ability to implement change and sustain that change, particularly the likes of Mr. Cadena, his modelling for the dairy sector, I think is really useful. Mr. Sheehan explaining the challenges associated with changing some of that historic infrastructure. Mr. Anderson talks about how farming businesses can fund change. And so I think, there is information that you can kind of pull the threads together and stick your finger in the air and undertake some analysis of whether, timeframes are ambitious but reasonable. But I think what that demonstrates to me is the importance of having a provision or a process in the RPS that enables the revisiting of that as we get more information and better information and more detailed information, as we understand the standards that are being set in order to achieve the visions, and then can really get into the analysis about what is required. So from our client's point of view, that is the fundamental, I suppose, ask here, is to have an RPS that reflects that iterative process that is inevitably going to be required. I think yesterday, Ms. Boyd, in her opening, talked about that particular provision and whether it was necessary, and sort of indicated, well, I don't think it is, because we've got a land and water plan coming in a few years and we could review the RPS in 10 years. But I think what the farming witnesses are telling us is that the uncertainty in not knowing whether things are locked in and what they're going to need to change, that is one of the most difficult things that they have to manage. And so in my view, a provision that allows us to make alterations sooner rather than later, where we identify that where we need to get to is either too far away or too close, then let's get on and do that. Let's not wait until we review the RPS again in 10 years, because otherwise you're going to have committed the sector to implementing the vision as it is as from this process, only to change it again potentially in 10 years' time. If we identify that change is required through that land and water plan process, let's get on and do that and get everyone moving together to implement that. So, and I think that is necessary in order for the provision around relying on the best available information to be implemented. We shouldn't be ignoring good information because we've set a direction of travel in the RPS. Let's be more nimble than that. And that's effectively what our process provisions are trying to achieve.
Okay, I thank you for that.
In essence, what the council position seems to be is that the visions are at a very esoteric level, and in reality can be described, only be described in very general terms, and that what follows is the NOF process, which when you look at clause 3.7 of the NPS-FM, starts getting into the detail, starts identifying the FMUs of the region, identify the values for each FMU, set the environmental outcomes for each value, identify the attributes for each value, set the target attribute states. All of those details that we appreciate your people are desperately wanting. It's the council's argument that that's the next stage. That's the land and water plan. And that in visions terms, all you can do, because you haven't got the information, because that's coming under the NOF process, all you can do is set visions at a very esoteric level. Do you agree with that?
I mean, yes and no. I agree that they will, as a matter of necessity at this point, be at a reasonably high level. But what the NPS provision requires of the visions is the setting of goals. And to me, that does require more understanding or more clarity about what the endpoint is. And that's necessary, because I think I spoke with Sullivan about, to understand that ambitious but reasonable requirement. And I mean, the way that the NPS is structured in that regard isn't, like, it's not super helpful, because as you point out, that the detail of the information you are often not going to have available until the land and water plan process. But the visions set the agenda. We must give effect to those visions when we are developing the land and water plan. So we need to, they need to be something tangible. They need to be something that we can understand and that we can point to the end point that achieves that vision. Otherwise, they're almost meaningless.
If you put it the concept of what you're criticising and your clients are criticising, namely that there is no specific or express recognition of a thriving, viable production ability through use of irrigation, that alone could be a vision.
Yes.
And a goal.
Yeah.
And do you have to go any further than that?
Well, I think that takes us back to that, I suppose, that key point, that the visions do need to cover the field. The visions are, to my mind, an articulation of sustainable management, or te mana o te wai. And so it encompasses the environment, the wider environment, or the water, the wider environment, and the communities. And so if we are to set the community as a whole up to have the robust conversation that needs to happen at the land and water plan process, the vision needs to identify that full suite of elements in order to allow that conversation to happen in a way where, you know, everybody gets to speak to and provide for the things that they need. I can, like, if the visions sort of stay as they are, absent the recognition of effectively resource use to provide for community wellbeing, what I can see happening when we come to the process of providing more detail, setting standards and so on, I will not be able to point to anything in the visions for the farming sector that says that this is something that needs to be given effect to. That makes it very difficult for us to have that conversation about where on the continuum do we land to provide for that prosperous community. In my submission, that the consultation that has taken place, the themes were very clear. The communities believe in the environmental improvements that are required. As they've spoken about in the evidence, many of those communities have already been making significant progress to improve things, and they want to continue to do that. They also want to provide for their families, for their communities, and to have resources available to support that element of the environment. So that, to me, in order for that engagement or that consultation to be reflected in the visions, those aspects of that community aspiration need to be there. They can be in equally general terms as the environmental components. They need to be in there.
Just a couple of reference matters if we can, in relation to the issue of tomorrow or why, paragraph 60 made the statement in the NPS, the protection of Māori is an outcome in the PRPS. It is the objective. Are you referring to LFY01? In that regard?
Yes.
Yeah. And if you look at LFY01, in front of you by any chance?
I know that I've got it in here.
Well, can I just read it to you just
Yes.
to save time? The heading to it is LFY01 dash Te Mana o Te Wai. And then it commences, the Māori of Otago's water bodies and their health and well-being is protected. That carries on as to restoration. If one just inserted the wording, moved even the heading down and said through Te Mana o Te Wai, the Māori of Otago's water bodies, their health and well-being is protected. You couldn't complain about that, could you, in terms of clause 1.3 of the NPSFM?
I think it would be an improvement to what is there now. I think it is still the flipping of that structure, I think, does create the challenge when you compare it to clause 1.3 of the NPSFM. It's protect the health and well-being of the water bodies, and in doing that, Māori is protected. So doing X achieves Y. So I think that is important if we are to avoid some of the difficulties which I've identified in the submissions. And that is partly because begs the question, what is not captured in health and well-being of water bodies that requires protection? So it implies that Māori is something different from the health and well-being of water bodies. So what element of health and well-being of water bodies is not providing for Māori that needs to be protected? And then that then leads us down the path of, well, if it's something different, what is it? How do we assess that demonstrate it. So that's the concern that I have about the drafting change relative to the way that it's articulated in the fundamental concept. If you were to amend as you're suggesting, and I suppose it takes us back to the fundamental concept. And so we go to mana o te wai says health and wellbeing of water bodies protects the Māori, and then protect them, like, so you kind of end up repeating elements of it, which yeah, may create confusion.
You're essentially arguing that Māori is one aspect of Te Mana o Te Wai, and Te Mana o Te Wai involves that wider concept of the environment, which involves people and communities.
Yes. Yeah. Yeah, and I think when you work through, say, the requirement to engage with communities and tangata whenua in relation to the expression of Te Mana o Te Wai, it does imply that there's almost going to be two streams of understanding. Whether that's helpful or not, I'm not sure.
I'm not sure whether you heard me asking or discussing with Mr. Anderson yesterday the issue of the wording of balance in clause 1.3. It's not a very helpfully phrased wording at the end, talking about restoring and preserving the balance between, and then it has three aspects: the water, the wider environment. The environment is defined as including people and communities, but then it says and the community.
Yes, yeah, and I listened with interest the conversation you had, I think, with Mr. Cameron yesterday about that, and I would be very cautious about interpolating the term natural environment into the concept of the wider environment there. I think had it been intended that environment as it's defined in the Act was not the environment we're referring to there, I think they would have been deliberate in inserting natural or something similar. But I do wonder whether it matters in a way. And in my mind, what we've got to do is achieve the balance between those three things. And so if you imagine water, wider environment and communities as a three-way seesaw, they've all got to be in balance. So if environment, the wider environment also includes people, it doesn't actually alter how we have to deal with those things hovering in the air spontaneously. But what that particular part of the fundamental concept says to me is that it's in many ways a re-articulation of Section 5, that we need to provide for all of the things. And I think the MPS is a creature, as I said, of the Resource Management Act. It needs to achieve sustainable management. Sustainable management is very clear that that includes people in this generation and the next generation being able to provide for their well-being. So that needs to drive and inform what the visions include, which has to be that element of enabling communities as well as the environmental criteria.
One other identification, if I can, of a reference, you referred to the definition of you said, referring to Modi,
Mm.
you have a reference to LFYE1. So is that the sentence, page 168, what we've got, which says the Modi expresses mana and connection, which can only be defined by mana whenua. Is that the sentence you were referring to?
Is which paragraph of my submissions are you just looking at?
Sorry, you're referring to that, we haven't got page numbers.
No,
be
sorry.
careful of that, at paragraph 60, so a bit over the page. That's 4 lines from the bottom. The RPS states that Modi can only be defined by mana whenua.
Mm.
And then you've given a reference to E1, and looking through E1, I can only find that one sentence to that
Yes.
effect.
Yeah.
The Modi expresses mana and connection, which can only be defined by mana whenua.
Yes.
It's a bit of an ambiguous sentence.
That it
So
can
that's
only.
the one you're referring
Yes.
to.
Yes, it is. And I think, I mean, I also note Mr. Adams yesterday, reinforcing the importance of those matters being expressed by mana whenua. And I'm not arguing with that. I don't have any difficulties with that, but the challenge I think needs to be resolved is how that can be, I suppose, tested in a way. And that's something the courts have grappled with on quite a number of occasions, and where we sort of landed in terms of where the courts have landed in that, that these metaphysical concepts are affected by changes or effects in the physical environment. And so if there are no physical effects, can there be metaphysical effects? And where I get to with some of that is, well, if that's the answer, then let's set the criteria for those physical effects, and meeting those and satisfying those, we know that those metaphysical effects or concepts are provided for.
Final point, at paragraph 5, you said that the submitters do not want to go back to square one. Instead, they seek a suite of changes and new process provisions that provide a framework for the deficiencies to be corrected through subsequent steps of the process. And I just want to be absolutely clear in my mind about that I take it by that you're accepting the proposition that Mr. Anderson advanced to us yesterday, that this process itself, this whole notification submission, cross submission, now hearing process, is part of the engagement.
Oh, absolutely. Yeah, absolutely. And I think, as I said in the submissions, I think it is a particularly important step in this process, given the challenges that there were with the consultation process that's been undertaken. I think if there had been a much more robust engagement process, then possibly the scope for tinkering or making fundamental changes to the visions would be less. But here we've had a bare bones consultation exercise, and the submissions for this process were the first time that the community had an opportunity to provide feedback to the council on those visions. And so, I think it is a really important part of the process in this context. And I think, as Mr. Anderson said, you absolutely have the ability to make amendments to the provisions based on what you hear through this process.
So this constitutes, to use your phrase, the circling back.
Yes, I mean, it has to. It would, I think, in a perfect world, it would have happened a couple of times already, but hasn't. But this is part of the exercise for sure.
Thank you very much, and thank you for the thought and the way in which you express things to us. Thank you. We'll have a break for morning tea. for 15 minutes.
First witness I'm calling is Kelly Heckler. You should have your summary in front of you.
Right, we're all ready. Okay. My name is Kelly Heckler. I'm a wife, mother, farmer and community leader. Our family farm is Lauder Creek, a high country sheep and beef property in the Menehira catchment of Central Otago. I'm very devastated about the position we're currently occupying in the Menehira regarding freshwater management. As I've outlined in my evidence, there has historically been tension, bitterness and hurt between parties, which is stagnating the ability to move forward. When there is no communication between parties, there is no opportunity for solution finding, which then impacts on our communities, our farms and the environment. Our rural communities are the solution to achieving the significant changes in freshwater management that currently these people are hurting. The pressure these freshwater management changes are placing on people is immense. The proposed RPS in its current format will impact our rural communities. Businesses will no longer be viable. People will no longer be able to live where they live due to job loss. Schools will decline. Just because these changes happen over time, they're often dismissed by those who don't live in these communities, but the negative impact on well-being is immense. People in our rural communities want the best for our environment, as these are areas where our children grow, where the culture of our community resonates. Farmers want a thriving environment just as much as anyone else, if not more. The freshwater visions are significant, and we need more than limited opportunity to talk about that uncertainty they create. To deny this to the communities when they have to make significant changes to their life, as it is previously known, is untenable and creates a cycle of them and us and moving on to complete shutdown. We need circling back and open communication channels. Our growers and farmers don't leave the farm at 5 p.m. to go home. The farm is our home. It's our livelihood, and policies that threaten our farming business and threaten our home and our families, so understandably puts people on edge. Empathy goes a long way to help ease the uncertainty in figuring out what future freshwater management is going to look like together. This is the only pathway forward. We need to allow for balance in our policy setting, and then give rural communities the support to enable them to implement change that is specific to that rural community. Commissioners, I urge you to understand that real people, real families and real communities are going to be significantly impacted by any decisions you make. Please allow our people to grow, our communities to prosper and our environment to thrive, as I truly believe we can have it all when we work together. Thank you. I'm welcome any questions you have.
No, thank you very much, Ms. Heckler. I have no questions. I think we had quite a conversation last time you're here, so fully understanding of your position. I guess the only thing is, and it does relate to that process that you're involved in, the consultation engagement process, is the opportunity, and I was trying to find one that's whether how you are offered the ability to actually provide your visions, because it appears from a lot of the evidence that you're really just given a form that you had a range of things. Now, I'm not quite understanding how that worked, but you don't have it, other witnesses have it, and there's dots associated with the various statements. And I wasn't sure how that worked, what that meant. Do you recall how that worked?
Well, there was we obviously got given this pamphlet, and then there was obviously the meeting, the heated meeting, and then the survey. But there was actually obviously that pamphlet was talking only about the ecological visions or values, and they weren't even visions or values then. They were almost just points about how we're going to manage the river, and then there was no there was no talk about values or visions as such. Yeah, we didn't have dots. We got that form, and then there was another form that had a set of minimum flows on it, and another survey subsequently that said, do you want 5,000 litres per second at the camping ground, or do you, and went right through, had 5 options right through to I think 1,000 litres. And yeah, but it's just been a survey. There's been no opportunity to actually talk about what the visions are.
Yeah, I guess that was actually my point, because the other witnesses did have a table with a range of visions, but yours is a pamphlet. So I'm wondering if it's the same consultation process, or is this?
Yeah. So with the Manahira here,
Slightly
I think
different.
because of the work that had gone on in relation to minimum flow setting and so on in that catchment, they actually didn't do a consultation process associated specifically with this RPS. So that the council, I think, relied on information they had gathered through the other processes, and yeah. So the dot exercise that was done and is discussed in the evidence of the other witnesses that were in different catchments wasn't done in the Manahira here.
How does that sit legally in terms of an engagement process under the MPS?
Well, I don't think, when there hasn't been a specific MPS vision engagement process in the Manahira here. Whether it's enough to leverage the existing work that has been done. I mean, I don't know. There is no doubt there's been a lot of work done in the Manahira here, and so whether the council would have learned anything new, I don't know. But I think from discussing matters with the likes of Kelly and others, they certainly would have appreciated the opportunity to talk about the visions, particularly given, as we've said before, the visions are setting the agenda now. So
It does feel there's a gap being missed in the Manahira here. We're having these meetings, these surveys, and then all of a sudden now we're at the freshwater vision side of it, and it's like, well, how did we get to here? Because we feel like we've missed the part in the middle as such in the Manahira here.
Yeah, it almost slightly jumped to the freshwater plan. I guess that's probably a question we might have for staff around that. No, thank you very much.
Just to demonstrate my ignorance, what's a brassica wintering system? Can you explain that to me?
So that is using species like, well, fodder species such as kale, fodder beet. It's not technically a brassica because it's a beet, but it's still in the same classification. Rape, Swedes, turnips, those varieties to grow specifically to winter stock on through the months of probably June, July and August when we have no pasture growth.
So any reliance on freshwater or water generally is no different from what you would expect just from a more repasture point of view?
No, we do rely on water to grow brassicas. We sow brassicas in anywhere in the summer months, and the yield difference between brassicas under irrigation and brassicas in a dryland situation could be, well, you could be looking at a 15-tonne brassica crop under irrigation versus a 3-tonne brassica crop under dryland, for example. So water is very limiting, and so in some systems, farmers use irrigation to grow winter feed primarily, and then it's grazed in situ or can be, in case of fodder beet, lifted and fed in other places as well. So yeah, there is a significant reliance on irrigation water in those brassica wintering systems. Yeah.
And do you do extensive irrigation?
Yep.
Okay.
So we have irrigation on our flats. So it's we have contour irrigation on one place, and on another place on our other farm we have centre pivot irrigation as well. So ideally we'd obviously like to move to more towards centre pivot irrigation, spray irrigation, but it's just the we've got a 6-year permit, quite a lot of uncertainty around that, and also funding it, especially at the moment with interest rates so high. We can't do it at the moment. So yeah, but going forward, that is definitely on the cards what we want to change to at some point in time in the future. Yeah, we don't like contour irrigation isn't, it's not, it's got limitations, and we do definitely be cognizant of those limitations, and but there also are issues with adjustments to water tables from contour irrigation that no longer occur due to the changes in irrigation practice, which is impacting on some people's bores and things like that. So
Okay, thanks very much.
Yeah, thank you, and thanks for making the effort to come back and speak to us again as well. Just one question: have you seen or had input into the vision that's proposed in the appendix of Ms. Perkins's evidence? I was just wondering if that sort of, if you were happy with that as a vision, where it has, I think, 2050 as a timeframe for the Manahira care.
Yep.
So I can't tell you what page number it's on because there's not any, but it's in LFBM 02.
Appendix 1.
It's where there's blue stripes.
Yeah. Yeah, so we're saying that we would have to, okay.
So what Ms. Perkins has done is she's taken some of the sort of overarching ones and put them into the individual visions, but there's I suppose she's suggesting some additional sub-clauses in there that recognising land-based primary production and
Yeah.
rural communities and
I think that we previously we would support what Ms. Perkins has put in there at the end of the day. So that's to 2050. She has listed the Manahira care rohe. Like we understand that change is going to have to happen in our community, and we are driven by the intergenerational aspect of actually making sure that our businesses can actually go forward for the next generation. And what she's listed in here about supporting primary production it does actually enable our businesses to actually be viable going forward. So yeah, we do support what Ms. Perkins has written.
So that was sort of some of the key things, the key things that you found were missing from the vision is.
And like obviously dealing with allowing that out to 2050 actually does give a transition period, and it actually does give time to make these changes. We're talking about significant capital investment in some of these places, and actually having that built in over time will allow it to happen, because otherwise, if we don't have that capital, or we don't have that ability to acquire that capital to actually implement these changes, it won't happen. So 2050, at some point we have to draw a line in the sand, and 2050 seems reasonable. And I'm pretty sure most farmers would suggest that 2050 would be a reasonable timeframe in the Menehir care. I can't speak for everyone, but
yeah, in your view,
yeah,
you think that what's down there seems
yeah,
challenging but achievable.
yeah. Like one of the things I think, improve resilience of primary production to the effects and to the effects of climate change. Like we need water storage, and we're talking $100 million, $200 million to come out of that Menehir care catchment. Like that will improve our resilience greatly, but to get the money to get that together in our small community, just it can't happen, within a year or two. It's a long-term outcome, really.
Okay, no, thanks.
Thank you.
It's to be particularly difficult. I see in the comments that Ms. Perkins has on the right-hand side. She's actually recommended 2060.
Yes.
Rather than 2050. It didn't come across. Was that discussed, or was it an issue?
2000. Well, what's the offset if we wait another 10 years? Some of the stuff we need to get in and get done now. Yeah, we've got to front up to it. Like it's 10 years, that's 10 years that the next generation is going to have to deal with. And I don't really want to be passing that on to, my children. Like I want to do what I can now to ensure that they actually have the option to be sustainable, but it has to be reasonable. I don't want to do everything I can now and have no funding to do it and run out of money and the whole business go under. Like, yeah, it has to be sustainable financially as well.
The only other question I had arising in respect to your evidence was just for the pamphlet, the various scenarios that would have provided a minimum flow rates. Where was the monitoring point for those? Was that
yeah, it was at the camping ground, but it was not
camping ground where?
In Alexandra,
right?
Which we subsequently found out afterwards at the meeting that we attended. But yeah, that wasn't stipulated on the pamphlet either, causing quite a bit of confusion and yeah.
And the final thing was just, I noticed in the pamphlet that there was reference to an online, and that's the online survey form you were talking about, right? And prior to that, there was reference to a staff presentation at 4 p.m. There was tell us which scenario you prefer in person. Then one Omako Hall on Friday 28 May, any time from 1 p.m. to 6 p.m. will be a staff presentation at 4 p.m. What occurred between 1 and 3, Yeah.
No, well, I don't know what occurred between 1 and 3.
Yeah.
Well, or 1 and 4. I think the initial concept was to come in and talk about it, but most people descended on the venue at 4 p.m. and there was a presentation about this pamphlet, and then subsequently told that that only applies to 1/3 of the Manahira care, the bottom third, and then but it was almost too late then because everyone was already highly in flight mode and pretty angry, and it wasn't a great meeting to be at, and and then 6 p.m. came, and then it was just no, we've got to go, cut off. So I'm not actually sure what happened between 1 and 4, but I'm assuming a few people went in there and did have a conversation with the staff.
Right, thank you very much. And I just want to make the observation to you that we're all grateful to you for the distance and time that you put in, the distance you had to travel, the time you put in to make sure that you came here. And I'd like to acknowledge and thank you for that. And also all the other witnesses for that matter who are coming today. And but just to regretfully point out to you that, as you will have already heard through the course of the morning, the real nitty-gritty, the real effort you're going to have to put in is going to be the NOF process that follows. And, so I'm sorry it's not all over yet.
Thank you very much for hearing us, and we realise that there's a lot of work to do going forward. So
Okay.
Cool. Thank you.
All right, and now I'll call Joe Hay. Just before Joe gets started, I've got 2 other farmer witnesses to call today, Randall Espinal and Logan. If possible, I'd like to call them before we break for lunch.
No
both of them have got lambing rounds they need to get back to this afternoon, so are on a constrained timeline. That's all right.
No problem.
Thank you. Hi, I'm Jo Hay, a sheep and beef farmer from Herbert in North Otago, a wife, a mother of 3, and what I would like to think an engaged community member. One of the many hats I wear is being part of the steering committee for our local catchment group, North Otago Sustainable Land Management, or NOSLAM. NOSLAM has a vision to have an environment we're proud of, a vibrant community and strong agriculture in North Otago. Our purpose is to educate, assist and encourage the North Otago farming community to farm in conjunction with sustainable land management objectives and practices. The group was originally formed in the 1990s to deal with the soil conservation and what was the dry land landscape. Those issues were managed through the development of irrigation schemes, and NOSLAM went into hibernation. That was until it was revived about 10 years ago to deal with the freshwater quality concerns. Since then, the group has been heavily involved with the community. The buy-in of farmers within our catchment is huge. Some examples of recent NOSLAM work streams include winter grazing, where we saw the issue and worked with the wider industry to bring everyone up to speed. Now everyone who is engaged in a wide variety of workshops has a clear understanding of good wintering practices. Riparian plantings. With the help of Jobs for Nature funding, we have plantings dotted all around North Otago. Farmers paid for fencing and the funding paid for plants and maintenance, and achieved a greater engagement and improvement of water quality. And a biodiversity corridor at Bowally Creek, where 11 different landowners have planted their boundaries the whole way down the creek from the source to the sea. NOSLAM's purpose and goals are driven by taking people with us. Much of our work involves the wider community, for example, Lions, Rotary, a soil Urundi's project within schools and in engagement with local schools, of which we have now engaged with 21 out of 23 schools in North Otago. The community and NOSLAM are both thinking long-term and intergenerationally for the area. There is so much good stuff going on. In my view, the local catchment groups have the most potential to affect change within our catchments. We've been able to achieve substantive improvements already without regulatory controls.
This needs to be acknowledged and reflected in policy. Farms in Otago sustain families, which sustain communities. They're also businesses that contribute to the economic growth in the region. North Otago has a long history of agriculture and is part of the fabric of the community. I participated in the workshops held by the ORC in relation to the freshwater visions to help represent this part of the community. The vision in the RPS for Otago does not reflect fully the values identified in the Oamaru workshop. I don't disagree with the environmental values that have been identified within the vision, but it doesn't reflect the other values that the community articulated, like maintaining a high production food industry, maintaining rural communities that are thriving, and certainly in relation to water allocation. Nor is there any recognition of the importance of existing irrigation schemes within the vision. In my view, the visions do not reflect the community's aspirations. They seem to have a very narrow focus, and I'm concerned about what this means for the rural community in the future. It doesn't appear to be recognised as an important part of the vision for the future. And if there isn't a shared vision, we will see a lack of engagement. When making decisions, we must remember that everything is interconnected. For our region to have a sustainable future, we must ensure the three-legged stool of sustainability is balanced. The three legs being the three Ps: people, planet, and profit. As farmers, if we don't look after the economics, our businesses suffer. We can't sustain their families or the communities. If we don't look after the people, there is no one to look after the land. And if we don't look after the land, our businesses suffer. For us to make a decision, we can't only look at it with one leg of the stool, or it will become imbalanced and fall over. The land must sustain the people. Our decisions are for us today, they're for our children tomorrow, and they're for our grandchildren not yet born. And while what is before us is about land and water, ultimately it's about people. Our decisions must enable the people and the communities to thrive alongside the environment. Thank you, and I welcome any questions.
Thank you, Mr.
Thank you, Ms. Hay, and good to see you again. Now, last time you were here, I think we were all staggered about all the things that you do in the community, and you've gone and added another one. Meet the need.
Oh yeah.
Yeah. Well, we always tell this fella here off for taking on too much work. What does meet the need? How does that work?
So it's a charity that was formed in 2020 that enables farming families to donate protein, whether it be meat or milk, and then it goes into food banks and is distributed to Kiwi families in need.
Okay.
So it's a national charity.
Yeah. Yeah, so you're on the local board or on the national
No, the
board?
national board. Yeah.
Yeah. Which means you're all over the country, probably.
Not really.
No.
Zoom's a wonderful thing.
Your paragraph 9 in your summary, what this NPS requires is an expression of what Te Mana Otawai means in a Otago context. I read paragraph 9 and it's pretty much, it seems to suggest to me what your expression of it is. Would that be fair?
Yeah, I think so. I think it's all very well to look with one lens, but when we only look with one lens, we forget the others. And we've got to remember that for something to be balanced, for it to be a long-term sustainable decision, whatever we decide, we can't, if we look with one heavily balanced leg of the stool.
So when you went into that process you talk about in your evidence in chief, the Oamaru workshop, did you have the opportunity to express that? Because I'm not sure. So you talk about the copy of the notes that you received, which are attached to your evidence. So whose notes are they? Is that what was presented to you and you were to comment on? So I don't understand the dots. What do the dots mean on those? The vision worksheet.
The way I remember it was just like an incredibly frustrating process. I was just talking about this before, where you know, there's a whole lot of sheets of paper in the room and the dots, and you get stuck in these tunnel vision discussions. We're in this discussion I could not get out of about what chimney or what fire is the best to get clean air. And I'm like, for goodness sake, can we pull it out of the weeds and get back to what we actually need as an overarching vision? And I kind of felt there's not the opportunity to get out of that. It's a tick box exercise where you're expected to have things fit into certain categories or silos, I guess, to make policy. When we're setting a vision, we need to actually have a wide overarching lens.
So you don't really get the opportunity to express what you've expressed in 9 through that process.
No.
Okay, well, thank you very much.
Yeah, I'd be just interested to learn a bit more about the lip gloss and gumboots survey. The survey that you did, and you listed here the participant 1, 2, 3, 4, and the sorts of things that they did. Can you tell us a bit more about that survey?
I can. I essentially wanted to, just out of interest, wanted to know all the people that are engaged within our group, and not all of them, and it was very, very short time frame, much like actually one of these ORC processes that we go through. So everyone that could reply to me within a really short time frame, I asked them a few questions, and one was list for me what you do, and the second one was tell me if right now your ability to give to all of these things is under threat, and tell me what the future might look like. And they, as you can see, they all listed a huge amount of things that they do. So I'm no different than anybody else in our community. Lots of people give to a lot of different things, and all but one said their ability currently, and this was at least, was it about November last year? Can't remember the date of that. So quite a while ago now. At that point, everybody apart from one was under threat, and nobody could see that they could continue at the level that they were at in terms of giving of their time and what they do for their community.
Interestingly, a number of them are rugby referees. They're probably needed in Paris right now.
Possibly.
Yeah. The other thing that caught my attention was the sort of intergenerational stuff here. I'm looking at photographs that you put in there for children and their grandfather and all that sort of stuff, you know, that which is a kind of I guess that's a community thing anywhere you go, really. I mean, and partly because I'm not really that familiar with North Otago, but can you tell us a bit more about that?
I think, like, we're pretty fortunate in our farming business that we have 3 generations living on farm. That our children who are now 14, 12 and 9 get to work with their grandfather all of the time. He's in his 80s and still comes to work. But I don't think that's that different than a lot of farms in North Otago. There are an awful lot of farms where the people my generation are running the business, but the generation before them are still involved in that business in a daily way. And their children are all involved too. So, and I think that intergenerational piece is really key, because it just, like, you know, and as Kelly said before, we're not making the decisions that we're making now for us right now. It's also thinking about what we're going to pass on to our children.
Thanks very much.
Yeah, thanks for that. So how many, I suppose, you know, you talked about intergenerational farms there. How many are more the corporate farms? Is that really starting to come in Otago quite a lot, or I suppose we've got
And,
Yeah,
and
I
North
suppose-
Otago, yes.
owners who don't live on the farm.
Yes, and North Otago, particularly, and I guess I can say this with my irrigation hat, a lot of the dairy farms are corporate owned or have more of a corporate ownership structure. I couldn't give you a percentage off the top of my head, but there are a number of them. However, there are still a huge proportion of those that are still intergenerational farms, and they may have once been a sheep and beef farm. They've since had somebody else come home and turn it into an irrigated dairy farm, but still with those same values of having a business that can support others. And when we look at it, we were talking about this the other night, when we look at it, is what irrigation has done for our region. Once we had schools that were struggling to keep open, now we've got schools where we're all struggling to find another teacher. All of those things, roles are increasing, and it's because we're supporting more families, which is pretty cool to be able to see the communities thriving the way they are currently.
Have you, I just asked you the same question I asked Ms. Heckler as well. Have you looked at the vision for the North Otago FMU that Ms. Perkins was included in the review? Or did you have any input into that?
I had a real good read of it last night, actually.
Because I think that's got a
I wrote a week in notes.
2015 time frame.
Yeah, I did, but again, I was kind of, yeah.
Does it resonate with you at all? Are there sort of tweaks or anything that you?
Yeah, it does. There was a part in it where, sorry. No, there's a whole lot of detail that goes with it, wasn't there, that I really got into last night.
We sound a bit like my evening. I suppose I'm assuming that
Yeah,
what you're wanting to see coming through the vision is around those thriving rural communities
Yeah.
and
it is.
acknowledgement of primary
Yeah.
production. That's sort
Yeah.
of,
And
sort of
it's,
thing. Yeah.
I guess what is heartening to see in this is that there's this, where it says point B, under this innovative and sustainable land and water management practices, talks about enable continued social, economic and cultural wellbeing of rural communities. And I think that part's key. We can't just make decisions without taking into account that social and economic and cultural wellbeing side.
That's all for me. Thank you.
There's a real thrust in your evidence about the voluntary aspects of these certified freshwater farm management plans, and you're in that paragraph. Want some clarity on one thing. In paragraph 39, you talk about the actions that might ensue from those, and said these actions may encompass A, catchment actions, B, regulated actions, and then C, supplementary actions. What are the supplementary actions? So as I was reading that, I read A, catchment actions. I read that as being a voluntary action. That
Sorry,
flow.
we're about to reading from.
paragraph 39.
Jonesy minutes.
I thought it was. I might have, no, sorry, I've flicked. Sorry about that. No,
It's
but
okay.
that's questions of
Kate's
Kate
minutes,
Scott.
isn't it?
Yeah, sorry about that. I've flicked
Okay.
briefs. So, that saves
Starting
you-
to sweat.
It saves you answering that, that's all right. And I'll leave those catchment plan questions for her. In that case, let me just check. No, you're pleased to know that yours was clear for me, so I don't have any particular questions for you. But again, I just, as Alan Cubitt said, take my hat off to both yourself and all the people we're hearing from, because the amount of work and effort you're putting in is staggering, and it's just a pity that it's got to increase, I'm afraid, as time goes by. But you're aware of that. Thank you for
Yeah,
making the effort to
thank
come
you.
today.
Thank you. Thank you for the opportunity to speak.
Right, so our next witness is Logan Wallace, who's joining us remotely.
And does he have a short brief?
Beg your pardon?
Does he have a summary?
Yes, he does. Gus will get that to Jack.
He should pop up when he turns his camera on.
Hi Logan, can you hear us and see us?
Yes, I'm just closing the live stream, so I've got a wee bit more internet available.
We can see you and hear you, so.
Yep.
You've got a short summary that you'll take us through.
Yes,
Box on when you're ready.
my name is Logan Wallace. My updated evidence discusses the Freshwater Visions process as it relates to the Pomahaka catchment group located in the Lower Clutha Row. Back in November 2020, I went along to an afternoon-evening consultation on the Freshwater Visions at Tapanui, which is part of the Clutha Mata'ao FMU, the Lower Clutha Row. Other members of the community and farmers attended from our district. We discussed the importance of a thriving rural community and the importance of agriculture before the council staff arrived. Despite every person acknowledging the importance of thriving agriculture, none of those words were included in the visions that were released. We want thriving rural communities, and to achieve that, we need thriving agriculture. The visions that have resulted from this consultation do not reflect what our thoughts were. We are part of the Lower Pomahaka, one of the problem catchments, which has been highly modified historically. They are now almost all mechanically straightened waterways with impervious clay bottoms. The visions for the Lower Clutha state that opportunities to restore the natural form and function of water bodies are promoted wherever possible. Although the work that our catchment group is doing is focusing on long-term improvement of water quality, I'm not sure that we would be able to return these water bodies to their natural form and function. The modified waterways have created ongoing issues with bank slumping and high sediment load. There is a build-up of large amounts of sediment because of the exposed clay base. These waterways were traditionally cleaned every few years to keep water flowing. This was what was viewed as best farming practice at the time, but is now a discretionary activity. But you would be highly unlikely to get a consent because it is work in a waterway. The process to improve water quality takes time. The issues must be dealt with. We must deal with include turbidity and DRP levels. This will not improve quickly unless we have some sort of intervention. We need access to rules to enable us to use some of the tools at our disposal, e.g. sediment traps on our modified waterways to speed up the natural process, natural sedimentation removal. Other approaches are river specific, but could include gravel removal. Historic sediment is impacting and increasing the water levels in the waterways and creating negative outcomes. There are not any proposed tools to respond to this, and we're not permitted to do any work in a flowing waterway. And the small flowing modified waterways are where our problems are. Tools enabling intervention must be allowed to improve water quality outcomes. It is hard for us to have to deal with historic sediment issues, but also have unrealistic measures of water quality. That is, our creeks are never going to be pure, crystal clear levels for turbidity based on the nature of the water body and the surrounding environment. It is an unrealistic standard. The described baselines will not work for all waterways because the waterways themselves are all different due to their location and where their main water source is, geology, soil type, etc. The Pomahaka catchment group started with ORC Plan Change 6A. In the absence of guidance for what we could do to meet the new plan rules, a lot of local farmers got together to work out how to meet the rules. The catchment group allowed farmers to collect data themselves and figure out where the issues were and create solutions in response. Farming best management practices is now all about improving water quality and looking at all the impacts, not just about improving production, but looking at the whole environment, including our wider community. Our catchment visions for water quality are interrelated to the catchment group and the work that they do. This is not a short-term game, and the risk of getting it wrong impacts us all. External visions and rules mean there is less engagement and buy-in from a local level. Less participation in the local catchment groups means less sharing of ideas and innovations that are improving water quality at a local level. The bigger picture of getting it wrong is that we do not have a profitable primary industry and we're not going to support the rural sector. That impacts the social framework of our rural communities. Since Plan 6A, the catchment group has worked hard collectively to record, measure and make positive changes in freshwater management practices. Our catchment visions and goals are more reflective of our local needs than what is prescribed by the government. Thank you, and I'm happy to take questions.
Thank you, Mr. Wallace.
Yes, thank you, Mr. Wallace. I remember your presentation last time around the sediment trap issue, and your last comment there around the 6A process that led to the catchment group. I had some questions on Mr. Campbell, or Mr. Kane, I think it was on that. And if you can't answer them, that's fine, but it appears you are familiar with that process. And in his evidence, he talks about measured metrics, etc. And I'm just wondering, and it may not be a question for you, the metrics that were measured and how they relate to what's required to be measured under the NPS. Is there a correlation there? And has that information that you folk have gathered been utilised by the regional council?
So there is a direct correlation. We measure the same measures. So NNN, DRP, turbidity. We have held some of that data. The catchment group has held it. It is public available, but some of the initial testing was done through a non-certified lab due to the fact that the costs were cheaper, and because it's not done under the state of the environment monitoring guidelines, it wouldn't be the council can't use it for their own use.
Okay. It might give a useful guideline, though, baseline.
It's given it, the reason we started the testing is because the council baselines were saying the water was degrading, and it gave us no clarity around where in the catchment the water was degrading or what was the potential causes. So we started much more intensive monitoring so that we could pick out which areas of the Pomahaka catchment were causing those issues that were affecting the overall Pomahaka monitoring sites.
Yeah, okay. I guess the question that follows on from that is you've identified that this area there's a lot of modified waterways, and sedimentation is an issue with that historic sedimentation that occurs. Again, it may be an unfair question for you, but how do we express that or recognise that in the vision for the lower Clutha Rohi? We had Ms. Bartlett for Kaitahu yesterday recommending an amendment or an inclusion in that Rohi that kind of relates to this issue. It was about sediment and contaminant discharge being an issue in that catchment. You've highlighted why that's happened. It's just how do we express that without appearing to provide a solution in the visions? How do we express your future plan for that area in these visions? And has that been done in Ms. Perkins's amended visions? Sorry, that was very long-winded, but you probably get what I mean.
I can understand what you mean, and unfortunately I haven't seen the amended visions, but I wonder whether we have to talk about or mention what was historic best management practices and the time to transition, and allow a transition time to reverse some of the damage caused by those original best management practices.
Yeah, so the link really is acknowledgement of the problem, but it's the time frame to achieve the outcome sought.
Yes.
Yeah.
And we can't potentially reverse all that if we don't have tools to be able to do some work or to do some management of the waterways. It will mean we would need a much larger time frame.
Yeah, okay, so understand that. So again, thank you very much.
Yeah, I just want to go to, I guess it's page 25 of your presentation on farm waterways.
Yes.
And the very careful way in which you've used the words found and seen. Coda were found and tuna were seen. But to what extent are coda and tuna actually taken and eaten, I suppose, to be frank? On
my farm, I'm just I just want to protect them. There'll be no volume of them available for any harvest for consumption. There's not enough there for that due to the size of our waterway, and I wouldn't allow it on our property anyway.
But in the district though, is there much harvesting of coda and tuna?
I would not be able to know whether there is or not. I can, when I was young, remember coming across commercial eel nets on the Waipahi River, but that's 15 years ago, so I don't know whether that still goes on or not. There might be just a wee bit small amount of recreational harvest, but whether or not there is or not, it would be an unknown.
And just going from the photos that you provided on the waterways, which supports the fact, my perception that there's no gravel in any of them. They're just regular waterways without gravel in them.
Yes, so in our area and some of the other areas of the lower Clutha Road, it is all just mud or clay bottoms.
All right.
And traditionally, some of this area may have been drained swamp, or there's no actual natural gravel sources in the part of the catchments.
Right, thanks very much.
Yeah, no, thanks for your evidence. That's one of the things that I've been sort of sitting here grappling with is the vision for the lower Clutha Rohe includes opportunities to restore the natural form and function of water bodies. It says promoted wherever possible. And when I read that, you think, okay, that sounds like probably a reasonable thing to include, possibly. But when I look at your evidence and you're talking about possibly the amount of work that will be done to needed to be able to do that, in addition to the issues that you've got in terms of consenting and other things. I'm just interested, do you have, obviously has the group got a reasonable relationship with ORC? Is there a sort of a vision or any sort of discussion occurring about what the future might look like for the waterways and what the catchment group's aspiring to achieve?
There has traditionally been quite a good relationship with especially the catchment engagement staff of ORC. The issue we have had previously is the large turnover at the council of staff. So we build a relationship and then that staff member leaves. But that there is some input, but it does feel slightly strained at times when we get the visions almost presented to us before we have consultation, or at the moment with the water plan, we've got very rushed consultation that's happening in very, very tight timeframes and limited amount of time to do consultation.
What's the catchment group's vision for those waterways? I mean, do you think that, would you like to get them back to meandering? Do you want to keep them straight, or would you like to see some wetlands in there? Or what's your, I suppose, does the catchment group have a vision for what you want to see?
So the catchment group's visions are around making sure that we can get the water quality, or get good water quality so that we can all enjoy the waterways. But my view is we won't get the waterways back to meandering. Even if in some places you would never even know where the waterway originally was, or was there originally a waterway there, or was it all sort of swampland? The damage that you would do trying to put it back to meandering in a lot of areas would be probably worse. It would be equivalent of straightening the creeks and starting that whole process again. It would require massive amounts of earthworks and potentially release huge amounts of sediment. There has been some support from the catchment group in one or two places to actually recreate wetlands where there was wetlands, but they have been very big, expensive projects supported by Jobs for Nature, ORC, MFE, to help put the money in to actually fund that.
So potentially, for you, where it's talking in the vision about restoring natural form and function of water bodies, that could be problematic.
That would be very problematic. Think of the Clutha. It would have meandered across the delta, and that would have so how do we deal with that one? How do we deal with the dams on the Clutha? They affect the natural form and function of the Clutha. But we also have to remember that some of the barriers that have been put in are protecting our native species, because they're preventing the incursion of trout further up the waterways.
Yeah. The vision here has got a timeframe of 2045. It's 2030 for the Upper Lakes, 2045 for Dunstan, Roxburgh and Lower Clutha, and then 2050 for the Manukau Rohe. Does that seem achievable in a challenging way?
I think we can achieve really good water quality outcomes in that time frame. I just don't think we can achieve quite the visions as they want them back with the waterway back to their natural form and function. I don't see how we could get creeks back to meandering where they've been straightened, or even in some cases if we could actually put back wetlands. There's areas that we wouldn't be able to do it without effectively turning the whole catchment back into a wetland, which would be economically probably not possible.
Okay, no, thank you for that.
I was intrigued by your description of the sediment traps and your reference to the loophole, but you referred to Appendix 1, which didn't really describe that loophole, but more particularly, it didn't describe, when I looked at it, how you deal with the sediment traps at the present time, when you say that you're facing rules that aren't allowing you to enter flowing water. So you're showing in Appendix 1 sediment traps that are working, so you're trapping the sediment, but obviously it's got to be removed at some stage. How are you doing it?
So the loophole that was suggested by the council was you can do work within 20 metres of a structure to maintain a structure or maintain the integrity of a structure. So all these sediment traps are placed just above culverts and waterways, which gives us our structure. And then to remove that sediment, we are having to go in with a digger to remove that sediment. I've currently, all my sediment traps need cleaned at the moment, and we've probably got around 50 cubic meters of sediment. So 2 truck and trailer loads of sediment sitting in those traps, which we will be able to remove from the water body.
Thank you. Yeah, so I mean, in terms of the visions, what you're really asking us to do is in the lower Mapo area, you're asking us to acknowledge that there's a modified drainage system that somehow enables improvement of water quality by sediment trap systems. I don't know quite how we'd word that, but that's the problem that you're raising for us. That realistically, that without that opportunity, you can't carry on the sort of activity that you're doing at the present time.
Yes, there's in PC8, there was an allowance for sediment traps in ephemeral waterways, but it doesn't deal with the issue that we have in the permanently flowing waterways, and without intervention it will really push the timelines out on seeing water quality improvement, because all that sediment that's currently sitting in the waterways will have to flush through the system.
Yeah, and I noticed you referred to that. You talked about, and I put a query by it, how could that natural flushing occur? Is that reliant on flood events, extreme flood events?
Yeah, that's a reliant on flood events. So we've had, the reason why sediment traps are all full is this year in the winter, we had some really good flood events. So that was enough to open up the weed and start the sediment flowing down the waterways. And I've managed to probably catch a third at an estimate to 2/3 of the sediment that was moved by the flood event in my sediment traps. The rest has been flushed further down the catchment.
Yeah, no, look, thank you very much, Mr. Logan. You're coming from a particular location and a particular point of view that's different from others and raises particular problems. So thank you very much for making the effort and being involved. Thank you.
Thank you very much for your time.
Thank you, Logan.
Oh, sorry. I called you Mr.
Mr.
Wallace.
All right, so our final lay witness today is Randall Aspinall. Randall is joining us from somewhere around Wanaka and coming in via Zoom also. We haven't seen Randall before. We didn't call him last time. Hi, Randall.
How are you?
Good, how are you?
Good, thanks.
All right, so we can see and hear you, and you can obviously see and hear us.
Yep.
And you've got a brief summary that you'll take us through, and then there might be questions for you.
Cool. Just crack into it, do I?
Yes, go ahead.
Cool. So I'm Randall Aspinall, farming at Mount Aspiring Station, which is upstream from Lake Wanaka. My evidence was focused on explaining the efforts that we put in up here through our catchment group and how our group has developed organically since Plan Change 6A and gone through a series of steps to get to where we are today. Obviously, there's been a lot of catchment groups set up since Plan Change 6A went through, have been set up, have transitioned from water user groups or transitioned from previously formed land care groups. The Wanaka Catchment Group officially set up in 2017, but the seed of it started in 2014 when we went through Plan Change 6A mediation with the Regional Council. Through that process, we had a group around the Queens, Lake Wakatipu and Lake Wanaka and Lake Hawea. We mediated quite a few different specifics in Plan Change 6A, and probably the main outcome of it was that there wasn't enough information or knowledge available for either side to be able to back up their position. Following this, we did a project with the Regional Council, Land Care Research, and the farmers to do a overseer trial, a detailed overseer trial, calibrating that in the high country. This led to a beef and lamb project on 3 farms to develop a consistent farm environment plan template that we could use in the high country, and was, I guess, specifically tailored to the wide range of soils, climate, stock types, farm systems that we have in our catchments. As this project concluded, we set up the Wanaka Catchment Group with, I think, 15 out of the 16 properties that significantly sized properties that flow into Lake Wanaka. And the main focus since then for the group has been implementing those farm environmental plans across each property. A lot of that is done one-on-one. So we've had a water quality expert working for the group, and he's spent a lot of time working with each property individually under the catchment group umbrella, which is probably one difference in our group, that we may have an annual get together and some winter grazing workshops, but a lot of our work is done on an individual basis, which allows our expert to work with farmers at the level they're at and to move at the pace that they're comfortable moving at, rather than trying to do it in a group with a full range. As part of these plans, we also did a good water project with the Otago Regional Council, which is a very targeted farmer-owned water quality sampling project. And the idea there was to detailed testing in maybe 3 or 4 sites on the same tributaries to directly tie land use to effect in the waterway. And a lot of that was just around evidencing for individual farmers the effect of what they were having, what effect their actions were having on those particular waterways. But it also allowed us to prove a lot of the critical source areas we'd identified through the farm plans and led us into the Waiora project, which is funded by MFE, Ministry for the Environment. And as part of that, we're doing, I think we've got 27 sites to be fenced, riparian sites to be fenced and planted with natives, with a target of 45 kilometres of fencing and 50,000 native plants. Plus there'll be, I can already think of 4 stock water systems that have gone in sort of in conjunction with some of these projects. While the Waiora project, it's great, the overriding intent of our catchment group is still around education and behaviour change. These planting projects look good and definitely have a benefit, but what we're aiming for as a group is to educate people and actually change their mindsets, and I guess be comfortable with being environmentally aware, and hoping that by going through that process we can actually get enduring change where they, I guess, take consideration of environmental awareness with all the decisions they make. In the wider sense of things, our catchment group has a loose vision of where we're trying to head, and we've discussed the implications of the higher level freshwater visions. However, it's not something we spend a lot of time on, and to be honest, we find the uncertainty, it doesn't help our group to get heavily involved in some of these processes, because the uncertainty it brings can be disengaging for a lot of our members. The Plan Change 6A thing is probably an example where we put a lot of work into that. We're broadly happy with the effects-based approach and where we got to. However, now it feels that that's disappeared, and in some of the preliminary FMU discussions I've had, seems we're almost starting again. And just some more examples there in terms of the uncertainty and the number of pressures that are out there in terms of the national freshwater standards, but also as a group, we've got ORC, we've got stock exclusion provisions, freshwater farm plans, He Waka Kanoa, labour shortage, health and safety accreditation schemes, biosecurity threats, none of which we probably know exactly where we stand, and all of which are pretty worrying depending on where we end up. And similar, I think there's some thoughts echoed earlier around the ORC. We've found some of the staff within the Regional Council really good to work with, and they've been really good at working with us and supporting when we've pushed for help. But the staff turnover has made it really tricky to get, like, I guess, a consistent relationship with people. We've put a lot of effort in at times and then seem to lose that relationship and start from scratch again. I guess because of all that churn I've just mentioned there on our farm, we tend to take not too much notice of regulatory processes as they're happening. I'll try and submit if I can, but in terms of our on-farm actions, we tend to just focus on projects and management choices that we know are good for the environment, and then just hope that once our expectations are finalised, what we've done will leave us in a better stead. I have to admit, I don't have a intimate knowledge of this process we're going through at the moment, but just my visions are my overall thoughts on the freshwater visions and that I've seen. As I said before, there doesn't always seem to be a heavy use of the work that's been done previously by the community, by the Regional Council and by other bodies. I think freshwater visions could do a better job of recognising the full spectrum of values held by our community. And so that's the benefits that arise from productive water use. right across the social, economic and cultural areas. And so like in our areas, recreational activities have a high value as well to the community, and not all of them are always represented as well as the economic activities. I think our group has demonstrated what can be done when we're encouraged to set up and do our work, and then are supported with that. And it's just an offhand aside comment that I probably think the lack of regulation in Otago over the last few years has probably helped our group, in that it's allowed us to get on and do what we want to do, rather than be overly concerned or challenged by regulation. And yes, I just encourage anything that's done to really recognise the value of catchment groups and the value of supporting them to be engaged and do what they can. Thank you.
Thanks, Mr. Ashton. Al?
And thanks very much, Mr. Aspinall. I'm kind of interested in your primary evidence around the Otago Catchment Community Steering Committee.
Yep.
And what you do there. So does that address, you've touched on it briefly in paragraph 11, but maybe you've got a wider explanation around what you guys do and what you help other catchment groups with. Is it around assisting with implementing like the freshwater regulations, those sorts of things? And have you seen improvements in those catchments as a result of your input, or areas that need improvement?
Yeah, I think we're probably not really in the implementation space, more in the support or facilitation space. So when you talk to catchment groups, and it's probably most volunteer groups in society, the issue is always around resourcing, burnout of key people, knowledge or ability to find resources. So the Otago Catchment Community was set up. We've got 2 employees on the road, and their primary role is to work with catchment groups to achieve their goals. And so that's around, like, it can be helping catchment groups run vision setting sessions. It can be around taking some of the administrative load off volunteers within catchment groups. It can be around just simple things like helping set up the first meeting in an area where if there's an interest for a catchment group, Anna or Sam can go in and just help walk through the process of booking a hall, advertising a meeting, getting people along. What are we going to talk about? Is to provide some coordination between groups in terms of sharing speakers. So if a speaker comes down from the North Island, they can maybe talk at 3 or 4 groups rather than one only, sharing findings. And then we also channel funding, I guess, from the regional council, really, and it channels through us to support groups with funding for facilitation, workshops, speakers, experts, on-farm projects, education days, all that sort of thing. Does that answer your question? Or
Yeah, and you also know that it is supported by the ORC. So in sort of what capacity is that? Is it around those issues, administration and assisting and bringing all those things together, or do they fund?
Primarily through funding. So the ORC and MPI are our primary funders at OCC. And so, and then we work with, so Sam, who's our coordinator, meets regularly with the ORC extension team. I'm not sure what their proper name is, sorry. Just to make sure that we're trying to work alongside with what we're doing.
Yep, and just in relation to the Good Water project in your paragraph 20, where you talk about the freshwater testing in the catchment, how long have you been doing that, and does that feed into the state of environment reporting that the OAC is required to carry out? Is it to the certified level, I guess?
No, it's separate to the SOE monitoring. So we did it. So we've done sort of individuals within the group have probably done water testing for 7 or 8 years now. But that Good Water project, that was over I think a 2-year period. And so the way it worked was, so we haven't, if you take the Tuki River, for example, we have a SOE monitoring site at the mouth just above Lake Wanaka that picks up the cumulative effects in the valley. And then with the Good Water project, we set 4 different testing sites up the river to, I guess, isolate it into 4 sections on the properties. And then we also went into individual tributaries that I guess we knew probably had issues, and then maybe sampled them on 3 different sites up the tributary to again evidence the difference in each of those reaches. And they were sampled fortnightly, but some of them may have only been sampled for maybe 6 months, and then we reviewed what we'd found, and if it was appropriate, we'd move sites to another area that I guess maybe had highlighted a concern that needed more investigation. So all results were kept private to the group, and it was very much about educating within the group. And so what we used that for was, in its simplest terms, like if through our farm plans we knew there was a farmer in the valley who was grazing crop paddocks with unrestricted access to the waterways, we would go and set a sampling site below the paddock, and we'd set a sampling site above the paddock. And then after we'd had 3 months of results, we'd take those results, show them to the farmer and say, this is the effect that your paddock and your management is having. So it was very specific around that kind of education and linking land use to result or effect.
And so the outcomes of that has led to management changes?
Yeah, it has. Yep. And I mean, in any group, as there is in any society, there is a range of uptake over how quickly those management changes occur. I can 100% say that every property has improved. Some have improved a lot. Some have improved a bit and still have some way to go. But definitely the use of that sampling, the Good Water project was awesome, just in terms of being able to take that detail and directly relate. And then it's what we've also used for the Waiora project, where we're planting and fencing areas and planting. We've also used the results of that Good Water project to, I guess, evidence or prove some of those sites that will really benefit from being fenced and planted.
Okay, thank you. Just one further question, and potentially a curly one. Yesterday you will be too busy on the farm, but some of the issues were discussed with some of the Section 42 report authors, and there was a request made by maybe I'm not actually sure, but it was to refer in the issue to not just farming it was to refer to that effectively poor farming practices impact on water quality, etc. There is a request to recognise that, but the report author suggested, well, there's no evidence to suggest that. So where I kind of took that, basically what she's saying, you could have the best farm management practices in place, but you're still going to potentially have an impact in the catchment that's not good. And that sort of leads to your discussion around Plan Change 6A, which was effect space. And the goal you say in your paragraph 32 wasn't to place restrictions on land use. In your capacity of seeing these catchment groups in action, is there a possibility or an acceptance that in some catchments maybe land use type has to change? Or can it all be managed by good practice?
Could I leave that to the catchments that it's hopefully more applicable to?
I don't know which one that is, but it's a general. From the officer's response is that, well, it's potentially signaling actual land use change in some catchments.
Yeah. I mean, I guess my thoughts are that so farming has an impact on water quality. We can't deny that. Just like urban development has an impact on water quality. So basically human activity has an impact on water quality, and we're all in that together. So we have to work out, I guess, the best balance between being able to live and enjoy ourselves and the impact. In terms of some areas, I guess there will be catchments where land use change probably does have to occur, and I suspect that even in our catchment, there are probably specific locations where land use change has to occur, and in some of that cases, we're probably seeing it. And so this is potentially like right on the lake edge. Maybe we need to have lower impact farming activities, or on some of our really gravelly flats, we need to avoid wintering or feeding large number of stocks because they're so leaky. My concern around land use change, forced or expected land use change, and it's probably not so much in our area, but it's the level of infrastructure and investment that's often been put in place by individual landowners. And in most of those cases, it's been put in place with the blessing of the regional council and the government at the time. And in some cases, and you see that in our valley, there's intensification and drainage that was actually funded by the government through land development loans. So if change needs to happen, I'd like to see that it's seen as like a societal change, or it's supported by everyone to happen, rather than the cost falling on the individual landowners who have been within the rules and within the expectations all the way through. And so I guess that means giving a clear transition out where they've got time to make the changes that are required, and some form of support to ensure that they can move through the process without undue hardship. Sorry, was that on the fence enough?
It's kind of what I thought you might say, but it's possibly not something we can influence. But very much for your presentation. It was very interesting and helpful.
Ken Randall, I'm assuming you're John's son.
Yes, I am.
All right. Because when I listen to you, I kind of hear John. You know, quite well over the years. But my question is leading to an issue I raised at one of the earlier presenters around intergenerational change. I mean, I as I say, I hear you talking and I hear John talking, the messages are pretty much the same. John had very strong views on a lot of the things that you've obviously got strong views on as well. But has anything changed since your dad's day, and what other things need to change, perhaps even more, having regard to your own children or grandchildren or whatever, the next generations to come?
Yeah, I mean, I think things have changed massively, probably from when Dad was around. It's probably, don't they say, the only thing that's constant is change. And I just think about even probably 10 years ago when I first came back to the farm, the kind of environmental practices, so just our everyday management, what we did then that we just didn't think twice about, that if we were doing that now, you'd be shocked and possibly on the front page of the paper for doing some of it. Just even around, in our situation, around stock access in some areas and the waterways and stuff like that. So I think there's been a huge amount of change has occurred in the last probably 5 to 10 years up here, and maybe the last 20 years in Southland and where I've had some exposure down there. And I just probably feel like things have maybe settled down a wee bit from a perceptional challenge for the farming industry, but for a long time there, it felt like change was happening, but the expected change was going faster than what we could do. So we were getting better, but the expectations were moving faster than we could keep up with. And I'd like to think that we're maybe starting to catch up to that now. And certainly there's some areas and some individuals that have probably still got quite a bit of work to do. But I feel like, and the discussions I have with my neighbours are very different, I guess, very different to what I would have had 15 years ago. And probably the discussions I have with the neighbours that are of Dad's generation are quite different to the discussions I have with our neighbours of my generation or the next generation coming through.
One of my everlasting memories of John will be the fact that he was a very much do it kind of person. You know, you sort of did it, and almost to the point of not giving a damn about anything else. And your job in life was to do things. I sense a little bit of that too in your presentation, that there is a sort of, I mean, rules and regulations are there to kind of not get in the way, but to help, as long as you can just get on and do it. And that's kind of and I'm not a farmer by any means, but that seems to me to be a sort of a farming diction. You know, you get out and do stuff. Would I be reading that correctly?
Yeah, I think so. And I think farmers traditionally have been get out there and do it, and perhaps detrimental to their ability to be involved in some of the regulations, some of these changes. And that is changing with newer generations, but it's definitely what so when I worked as a farm advisor previous to coming home, so I guess I was sort of involved with books and paperwork and knew my way around it. And I came home, and the first few regulatory processes that came up, I was into it, boots and all, to have my say and be involved in that. And then as I've got older and had kids and got busier with other stuff, you start to realise that you're having the same discussion now that you were 8 years ago. And that whatever you're working on now is probably going to change in a year and change again in 5 years. And so certainly I think my approach is head towards, and probably our catchment group, I was fortunate to be involved with Grant Running-Claw on that. So our approach has probably been, let's try and do what we know is right and what we will make a positive impact. And hopefully that will parallel the regulation as it comes through, or put us in a better stead for once the regulation is, I guess, clear and confirmed.
Yeah. Look, thank you very much. And it's nice to know that John's legacy persists.
Thank you.
Yeah, no, thanks. I think my questions have already been covered off, but I just did want to make one comment. You stated earlier that you'd like to see the value of catchment groups recognised through the RPS, and I think we've had a lot of evidence on on the really impressive stuff that the catchment groups are doing in Otago, and just want to highlight that's something that I'm keen to pick up with your planners when we hear from them this afternoon, as well as to where it might be appropriate to build that in or strengthen reference to those within the RPS. But we'll see.
Yeah. Could I just maybe add to that I think probably my comment around the strength of catchment groups is, and this comes from some of my OCC work and the catchment, is there's real strength in catchment groups that grow from within. So we have got people that are passionate and enthusiastic about their areas and are prepared to put the time into getting people together and doing positive work. And I 100% applaud your comments and encourage that to be included in the RPS. I do, however, think there's a concern if catchment groups are seen as the only way forward, and the way to get change is to go and forcibly set up a catchment group in every area, which we're probably seeing a little bit of in a national context in terms of funding going into areas to create groups. And I guess I'd just express a concern around that, because they tend to be quite short term, and it's hard to get genuine buy-in to something that's forced as compared to something that's grown organically from itself.
Yeah, and I think thanks for that. And I think what we've heard from you and the other witnesses is reinforces that. Yeah. No, thanks for those comments.
Thank you.
Thank you, Mr. Aspinall. There's been a lot of questions to you. I've just was looking at your evidence and your Appendix 1. I take it that your property encompasses both the East Matukitui Flats as well as the West Matukitui Flats.
Yeah, it does. Yep.
And so when you're talking about the, and I appreciate it was part of the Waiora project, so it's not just your property, but you're talking about a target of 45 kilometres of riparian fencing. And having walked up donkeys years ago, 1987, up to the Kitchener River, up those East Matukitui Flats in rain, the effect of that, is that riparian fencing, is it really feasible in terms of major river protection, or is it really tributary protection?
Yeah, it's mainly tributary protection is what we're aiming for. So because we farm fairly extensively, so our water quality sampling we've done on our property has been based around on our boundary in the East Branch, on our top boundary in the West Branch, and then sampling where the Mainstem River leaves our property. And through that testing, we've found very minimal to no change in water quality. And we're talking numbers so low. So we're talking E. coli counts of 4 or 5, which is 2%. You know, it's safe swimming is I think 125 or 250. So I guess in terms of our main tributary effects, because we've got a very low stocking rate over a large area, high water flow, hard bottomed main stem river, so minimal. We have a lot of natural erosion, but minimal stock created erosion. We see very little benefit in fencing off that main stem for a large cost, and it is actually not necessarily the initial fencing cost that concerns me. It's the maintenance that would go into, for us alone, it would be 50 or 60 kilometres worth of additional fencing next to flood prone rivers that we'd have to maintain. But what we do have are tributaries that flow through paddocks which are more intensively stocked, and a lot of them are soft bottom and soft bank, so they're very prone to effect by stock. So those are the kind of areas that we're doing through our project, where we're trying to target those sort of I guess the soft bottom creeks, or a lot of them that may be sort of wetland filter areas at the bottom of intensively farmed or more intensively farmed blocks or sections of the farm. A couple of them are looking to reinstate wetlands. Yeah, it's very much sort of critical source or high risk areas rather than looking at the main stem. Having said that, below us, there has actually been a reasonable amount of main stem fencing has occurred over the last 10 years anyway, just on the bat of individual farmers.
Right. Look, thank you very much, and thank you for making the time and putting the thought into it that you have. And unfortunately, as you've been hearing me say to others, it's not going to end, because the NOF process really is where the rubber really hits the road. So thank you very much, Mr. Seth.
No, thank you very much for hearing me.
Thanks very much, Randall.
Cool.
Now, where are we at with who?
So those are all of the lay witnesses. So we've got Kate Scott and Claire Perkins to come.
Right.
So I'm assuming you might like to take a lunch break.
Yes.
I've got a rumbly tummy. I'd like one. And call them after lunch.
Right. Thank you. Cool. So look, we'll start again at 2.
Great. Thank you. Yeah, Kate.
Thank you.
Thank you. So we'll call Kate Scott now, please. She will be joining us online, as will Claire.
Right.
Hi, Kate.
Hi,
So we can hear you and see you. Can you hear and see us?
yes, I can, thank you.
Oh, now if you've got a short summary that you'd like to take us through.
Yes, I do. I'll kick into things. Kia ora tātou, ko te ahu pātiki te moanga, ko kaukura rata te awa, ko ngā tahu te iwi, ko tūtei huariwa te marae, ko Scott toku whānau, ko Kate toku inua. So my name is Kate Scott and I'm a resource management and farm environmental planner. I'm also the founder and executive director of LandPro Limited. I refer you to my expertise and experience outlined in my evidence. The purpose of my evidence was to set out the broad suite of regulatory changes that are in place and in the pipeline which are affecting the sector already or that will affect the sector within the life of the proposed RPS. This evidence also provides a detailed overview of the convergence of issues that are at play, in particular the rollout of certified freshwater farm plans and the resource management freshwater farm plan regulations, and their interconnectedness with the RPS and other lower order planning documents. I note for clarity, whilst I'm a planner, I have not provided a full planning brief of evidence. However, I have provided some context to support planning matters where they specifically relate to the wider issues, including certified freshwater farm plans, visions and transitional provisions. I have reviewed the evidence of Ms. Perkins for the submitters and I agree with her conclusions and recommended changes. Change cannot happen overnight. The agricultural sector is subject to reform from all angles and this is not expected to change in the near future. The reforms already in place will take decades to implement properly, with much of the cost borne by farmers themselves. The sector does not disagree with the intent behind the reforms, but needs time to properly be able to implement them in a way that will result in the best environmental outcomes. Despite the uncertainty, there has been a significant shift amongst rural landowners and communities to do more for the environment, which has been led by voluntary catchment groups, resulting in a number of successful projects and on-the-ground practice change. Given that there is so much regulatory change currently being deployed in the rural sector, it is critical the combined and cumulative effects of reforms are considered by decision makers in determining whether the visions and objectives in the RPS are ambitious but reasonable. The RPS should recognise the need for transition and the need to take particular care to avoid unintended consequences as a result of new policy direction. This should be recognised through a more explicit approach where competing priorities are acknowledged and that where such competing values materialise, for example, water versus carbon, there should be direction provided about which response needs to come first because there are insufficient resources available to enable everything to be undertaken at the same time and still achieve better outcomes for the environment. Consequences for a lack of direction. The lack of clarity puts farmers in a position where they do not want to incur the cost of undertaking substantial changes on farm, for the regulations to change again and again, and for the work that they have done to be deemed futile. In essence, they are anxious about early adopter penalties. What the provisions should be trying to provide is an early adopter advantage so that the sector have the confidence to move more quickly. This issue becomes apparent through certified freshwater farm plans, which require landowners to document actions at a catchment scale, amongst other actions, setting out how actions behind the farm gate will meet and address the catchment context, challenges and values. Clear visions in the RPS at an FMU or catchment scale would set up for integrated management between the freshwater farm plan regulations and other planning instruments. This is because the visions can be responded to through the freshwater farm plans and assist the farming sector in identifying what things need to be focused on. Effective implementation of certified freshwater farm plans will be a key method for enabling and delivering Te Mana o Te Wai. I'm just going to go slightly off script for a moment, so if you can't follow what I'm about to tell you, it's because I'm actually just would like to respond to a couple of the points that Ms. Boyd raised yesterday in relation to the efficacy of the certified freshwater farm plan process and her questions about whether certified freshwater farm plans have outcomes or not. And I guess in my view, perhaps Ms Boyd has taken an overly simplified view of the purpose of certified freshwater farm plans. It is my opinion that the drafting of these regulations has purposefully avoided specifying outcomes in the regulations, as the outcomes will be different from farm to farm, catchment to catchment, and region to region. MFE have noted in various publications through saying or recognising that one size fits all does not work on farm. The point is that all certified freshwater farm plans must have actions which avoid, remedy, or mitigate adverse effects on freshwater and freshwater ecosystems that directly relate to the catchment context, challenges, and values. This is set out in the definition of actions and catchment actions within the regulations, as well as within Regulation 8. Section 217 F of the RMA also sets out that a freshwater farm plan must A, identify any adverse effects of activities carried out on the farm on freshwater and freshwater ecosystems, and B, specify requirements that 1, are appropriate for the purpose of avoiding, remedying, or mitigating the adverse effects of those activities on freshwater and freshwater ecosystems, and 2, are clear and measurable. It's at this point I refer to the definition of outcomes, which says, using a Cambridge dictionary, the result or effect of an action. So if we've got clear and measurable actions, then in my view, we also have outcomes. Without clear visions and an understanding of specific context, challenges, and values being set up through the RPS and other subsequent planning instruments, there is a risk that certified freshwater farm plans will fail. In my view, they were designed to allow actions to be determined based on the state of the existing environment and community aspirations for water quality, to ensure that where there is a gap between current water quality and the community aspirations, that action can be taken to close this gap within a generation. This will mean that in some catchments, actions may well result in significant change to land use. In others, where water quality may already deemed to be okay, perhaps less catchment actions will be required. If we fail to set this up properly within the RPS, then there is a risk of failure, and also the risk of missing an opportunity for integrated catchment management that certified freshwater farm plans were, in my view, purposefully designed to support. The design of certified freshwater farm plans, whilst currently untested due to the rollout only having commenced some 3 weeks ago, is intended to provide robustness in terms of the actions that a farmer is proposing to ensure that the actions will drive outcomes. The role of the certifier is to assess that the mandatory requirements of a plan have been provided for, to assess whether the risk assessment and actions set out in regulation are appropriate for the farm, and that ultimately the actions specified will deliver on the required outcomes based on catchment context, challenges, and values. Whilst first generation certified freshwater farm plans may be more simplistic, given the convergence of various planning processes, including creation of water and land plans, implementation of national policy statement for freshwater, etc. If we look out over the life of the RPS and future land and water plan, certified freshwater farm plans will be in their second generation. It is my view that these second generation plans will be much better placed to meet the commitments to improve water quality within catchments. This is because by this time, allocation of water quantity and water quality, goals and targets, smart goals, as Ms. Irving talked about this morning, and ambitious but reasonable visions and values will have been set. And therefore, rural communities will know what is expected of them and over what time frame, which then allows them to plan for that through their certified freshwater farm plan. This is because certified freshwater farm plans are mandatory, and they require farmers to specify their catchment actions, their regulated actions, and their supplementary actions. Take, for example, a catchment that through the RPS and subsequent land and water plan has set clear targets for water quality and water quantity that, say, would require a reduction in nutrient allocation of, say, 50% over the next 10 years to achieve the identified targets. Through the certified freshwater farm plan, the farmer would be expected to document what actions they are taking on farm to meet this catchment target and the time frame that they are going to act by. This approach also allows farmers to work collectively as catchments and through their catchment collectives to help to achieve these goals in a more holistic and joined up way. In regards to the example that Ms. Boyd referred to in Canterbury, around where perhaps freshwater or farm plans of some description may have failed, in my view, this is perhaps an unfair comparison, as these farm plans that she referred to were not certified freshwater farm plans, and to my knowledge were not required to be working to deliver agreed catchment outcomes, or in fact required to be developed to an agreed minimum standard, as is the case for certified freshwater farm plans. Further, Ms. Boyd's response assumes that farm plans are the only method that would be used, which is not what we are suggesting. Depending on context, other methods may or may not need to be applied. Equally, what we don't want is a separate and different farm environment plan regime to be required when a standardised national requirement is in place. Just coming back to the summary document that you have in front of you, paragraph 12. The implications of not providing clear direction and clear priorities are starting to arise in an Otago context already. There are many farmers being forced to decide between pastoral farming and the planting of pine trees due to rising uncertainty and costs. Is this what Otago wants in its catchments? Have the hydrological implications of mass pine forestry been considered? What about landscape effects on the soil resource? What about landscape and effects on the soil resource, let alone the economic and social effects on the community? This is an example of the lack of integration that can arise. So how do we go about fixing it? This can be achieved through clear visions and priorities and values, and by providing for a joined up, holistic and transitional pathway to implement and adopt efficient change on the ground. Regulations and their transitional timeframes must recognise that changes take time to implement, and because farms are made up of interconnected biological processes, changes may not show immediate results. Challenges for farmers need to be considered in a holistic manner, as a disjointed approach will have widespread effects on environment, economy, and community, as well as giving rise to a suite of unintended consequences. The role of non-regulatory methods and catchment groups into the future needs to be directed and secured through the RPS to provide ongoing opportunity for rural communities to meet the needs of their communities and their environments. Catchment groups have a role to play to translate local objectives that are more meaningful to landowners, as well as recognising that freshwater policy could be used to better incentivise collective management. We need clear transitional pathways to set clear integrated objectives and to avoid duplication. Thank you, and I'd be happy to take your questions.
Ms. Scott, you obviously read quite a significant piece of evidence between paragraphs 11 and 12.
I can provide that in written form, yes. My apologies, I came to that after having finished my summary and before it was able to have been incorporated into it, so I'll provide that as a separate piece of written information for you.
Right, thank you. And can that be sent to the hearings administrator today?
Yes, it can. Would you prefer me to just insert that as additional paragraphs into the summary document, or would you prefer it just as an addendum?
No, look, it's better if you insert it into the supplementary brief that you've given today. Thank you.
Thank you.
So we'll start the questions with Commissioner Sullivan.
Yeah, no, thanks, Ms. Scott. I did have a couple questions. Sorry, I'm just finding them here. This is just questions on your evidence and sheet. But I was just, I mean, you're putting quite a lot of emphasis in your evidence on the certified freshwater farm plans, and at paragraph 28, you seem to be I'm just reading this again because my question that I've got in the margin of your evidence here says, how's a vision going to inform this information? And I seem to have took what your discussion was there, that what ends up in the visions is going to potentially sort of feed into the freshwater farm plans. And I was just unclear, given that the information that's required in there is a lot more specific, that surely that's more of a LWRP issue rather than a RPS issue. Does that make sense?
Yes, I think it makes sense. I'll attempt to answer it, and if I haven't answered your question, perhaps you can ask it again. Look, my view is it's actually related to both regional policy statement and a water and land plan, and that's because we need to understand the broader catchment context, and that's obviously now set out for us within those freshwater farm plan regulations. But that includes things such as, I'll just bear with me for a moment.
Or see farm plan regulations. I think I was having a look at those, trying to sort of work out how all that fitted in.
Yeah, and look, from my point of view, the reason that some of the matters that will be contained within the RPS become relevant is because it talks about, for example, point or under Regulation 4C, it says any objectives, policies and rules relevant to the management of freshwater or freshwater ecosystems and policy statements or the regional plan. So that's a directive requirement. So if there's not a provision for joining these things up in our bigger picture planning documents, then we can't necessarily cascade this down through the rest of them. And so that's why, for me, they kind of come together as part of this integrated catchment management approach.
Yeah, okay. Sorry, just moving on to the next question that I had on your evidence here. I was interested just from looking at your evidence, and also I know you've had a lot of experience working with communities. How far off do you think we are from achieving those visions?
Look, I think in my experience, I think it depends a little bit on where you start. So some catchment groups, as we've heard this morning from Ms. Hay and Mr. Aspinall, have been coming together over a long period of time for a variety of different reasons. And so those catchment groups have had the opportunity to make more progress than those that are perhaps starting out. I think catchment groups, in my experience, are an exceptionally useful way of bringing people together for a common purpose. And in my view, their success has been underpinned by their ability to show that change can happen from the ground up. So instead of always taking a top-down regulatory approach, we're enabling them to drive the change because they can see the purpose and they can see the why, and therefore feel like they have some control over their destiny. And so I think that's where the success of that comes from. I think until we actually know, as I said in my summary, what the end goal is going to be in some of our catchments through the NOF process, through limit setting, etc., then we can't actually necessarily measure what the gap is today. So how far do they have to go? That will really vary from catchment to catchment. And I think, it's going to need a range of tools to help us to deliver outcomes for freshwater and also ensure that we can provide, as Ms. Hay talked about, the sustainability stool that we can provide for flourishing communities and, economically viable businesses and communities as well.
Yeah, okay. So I suppose one of the things you're pushing a bit in your evidence is moving towards non-regulatory measures where they might be appropriate. But one of the things that I struggle with that is, do we actually have enough information in front of us to be putting provisions in a regional policy statement that guides when non-regulatory and regulatory would be appropriate? Can you comment on that? I feel like we'd sort of be in the dark a little bit, just given that we don't have enough information.
And I guess this is part of the conundrum that we're dealing with, that a number of people have touched on, is that unfortunately we're living in a vacuum of not having got in front of us enough information. And that's where, what I tried to set out in my evidence was this more adaptive approach where, for example, when we get to the point of understanding what is required for each FMU or subcatchment or whichever approach is going to be applied, when we understand what is required in the gap in front of us, there could very well be some catchments within Otago or some subcatchments that are already meeting or exceeding water quality aspirations that have been set by communities, in which case, it's taking this approach of let's not penalise those farmers who are already, or those landowners who are already coming together to actually have delivered outcomes. So why create a greater regulatory burden for those people if they're already achieving the outcomes that have been asked of them? So it's about providing a mechanism that allows for, sure, where there's not where there's not been any meaningful change on the ground, or we can't see long-term trends that are showing an improvement, or there's poor water quality to start with, I don't think you can probably use catchment groups as a non-regulatory method. And I'm not saying that this should apply everywhere, but what I am saying is if you take the example of some of those catchments where they have come together collectively to manage the impacts of their activities, let's recognise that hard work through non-regulatory measures, and it's going to require an adaptive approach. And I guess the reason for articulating that as a concept through the RPS is that it then allows us to set that up as a framework for a conversation where the detail can then be developed through the land and water plan process.
Yeah, okay. I just was wondering if you could clarify your paragraph 78 in your evidence in chief. I was a little unclear about what you were meaning there. So are you suggesting that we should possibly have more ambitious timeframes that catchments for catchments that are more degraded and focus work there? Is that what you were getting at there?
I've just given me a moment, I'll just reread it. So what I was getting at there was around how do we prioritise which catchments we focus on. So for example, if you take one of our more degraded catchments within Otago, the gap that they have to effectively close is going to be substantially bigger than some other catchments. And therefore, what I was suggesting was that you might want to start by focusing on those ones because they're going to need potentially more help, more tools, more direction, and a longer period of time to implement that change compared to some of those catchments that may have less of an issue when it comes to existing water quality, and therefore the gap that they have to close is smaller. Does that clarify that for you?
Yeah, no, that makes sense. I suppose so that's more of an implementation issue than...
Yes, it probably is fair to quantify that as more of an implementation.
Okay.
Reflection.
Yes. Just around certified freshwater farm plans, and I suppose a lot of my work has been in Canterbury around freshwater management, where I suppose farm environment plans, as they've called them there, and before that they were freshwater environment management plans, I think, something like that. Anyway, FEPs and FEPs, but they've been around for quite some time, and dare I say it, water qualities continue to degrade, even though in a lot of catchments, and I know Ms. Boyd referred to Otawharakai, I suppose in some instances where, in Canterbury, where they're getting to is recognising that, well, maybe there's, it's not just a matter of trying to get existing farms to A-grade certification. There may be a little bit more that's required to achieve the targets and limits. I mean, to what extent you seem to be putting quite a lot of faith in farm plans to achieve an awful lot, and I'm just wondering what that's based on. Well, how confident are you, I suppose? I mean, I just suppose from where I'm coming from with Canterbury, it hasn't been a magic bullet.
Yeah, look, I'll share some views and some perspectives. Because certified freshwater farm plans are new, I don't probably have a huge amount of evidence I can present to you on their success or otherwise. But in my experience, I guess we've got to be really mindful of not just assuming that the way that Canterbury have done it is going to result in the way that it will be rolled out elsewhere. Yes, they've tried, but they also didn't have the same obligations upon their farm plans as has been required through the way that they've drafted the Certified Freshwater Farm Plan regulation. So, you know, I think we don't have a choice in their rollout. They are now mandatory, and we will have to actually develop and deploy them. I think, will they be successful? In my experience, I have certainly seen significant successes start to arise, particularly where in the past, I would say, where farm plans have been driven at a voluntary level. So it's fair to say when they first rolled out certified freshwater farm plans, I was probably a little sceptical that making these mandatory would do anything more than just drive a tick box compliance approach. And I'm trying to be open-minded about what that looks like. But what has actually been delivered in terms of the regulations is quite a detailed and specific set of requirements. And so, you know, I think if someone isn't delivering on the actions, then it's going to be incumbent upon the auditor to actually be evaluating why. And I think in time, and we've already seen some regional councils talk about this in a general sense, is how do we connect actions through our certified freshwater farm plans and make sure that, you know, where there's not action or there's not a difference or a better outcome being achieved, that's when a regulatory intervention may be required. So we've also got to bear in mind that the obligation for farmers around farm plans is more than just regulatory. There are a number of our processes out there that are requiring our farmers to prepare and deliver on farm plans that are meeting a consumer or market-driven requirement. So you take the New Zealand Farm Assurance Program, NZFAP, NZFAP Plus. A large number of our meat processing companies have signed farmers up to working under those plans, and that's about demonstrating transparency and traceability for the consumer that our farmers are undertaking good actions. And so that's an example of where farmers are choosing to enter that process voluntarily, and they are seeing good outcomes because of that. And that's about the market connection focus rather than the regulatory focus. So that's a bit of a rambly answer to your question, and I guess we are probably going to have to wait and see. But I think, you know, that it's a tool that we are going to have to work with because it's been legislated, and that's the reality that we are facing. And we therefore, in my view, need to look at it as how do we take this as an opportunity to create an integrated approach that avoids duplication.
Yeah, and I suppose what I've seen where farm plans have been used, they really do focus farmers' minds a lot more on how their practices impact on the environment, and has led to, you know, a lot of improvement in practice. One of the things when I looked at the farm plans, you look at the list of competencies for certifiers, and it's quite all-encompassing.
Yes, it is.
And I mean, it sort of says that you've got to have an understanding of all the regulations and certification requirements, but objectives, policies and rules, relevant freshwater matters. You sort of wonder, I suppose, are the people who you would probably be wanting to be certifying farm plans, which are probably the people who have got a lot of farming expertise, are they going to have all that other experience? I mean, how many people around could tick all the boxes in that list? I do sort of wonder where these people are going to be found, and therefore are the farm plans, if they're going to be really focused on the farm stuff, are they going to actually encompass the sort of broader I suppose all those broader things that they have to consider as well.
Yeah, that's something that was certainly canvassed through the working group that I was involved in terms of reviewing the draft regulations, and that the ministry sought feedback from those of us with experience in this field on. And having just recently, in the last couple of weeks, completed the online application form for certifiers. It was quite a detailed process to set out all my experience and expertise as to why I have capability to deliver in that space. But I think, yes, there is going to be a shortage of people that can bring together all of those skills. But what you will have noted is that the way that I suspect that they've tried to overcome that is by providing a two-pronged pathway, one being someone who might have some qualifications in one or other of those respective fields. Then the other alternative pathway is someone who has substantial experience. And then through that, the certifiers are going to have to go through a national planning or national training framework, which you're going to have to demonstrate your competency in terms of understanding the rules and regulations. And then there's a regional training component that has also been stipulated where you're going to have to demonstrate your competency in understanding the regional nuances that apply in the particular region you're choosing to operate. So it's kind of a belts and braces approach to that. But look, I think it's fair to say there will be, the way I described this the other day is perhaps slightly inappropriate, but that the first round of freshwater farm plans, I think, are going to be a little chaotic. And as we actually get through this messy period, the next versions of those plans, in my view, should actually strengthen once we've got clarity of what is required.
Okay, no, thanks, that's helpful.
Thanks, Ms. Scott. I don't have any questions for you. Bianca's covered it all off, as did your supplementary in relation to this particular issue. So thank you for your evidence.
Yeah, I don't have any questions either.
Ms. Scott, it's probably contained within that material that you read and which we haven't had a close look at, but can you just run through again for me what you say is the link between performance under the certified farm plan and the effects on the environment? So where the security really comes from, the sense of security comes from that.
Yes, so effectively, Regulation 4 of the Freshwater Farm Plan regulations requires farm plans to be prepared taking into account what they call the catchment context challenges and values, and that's looking at all the physical requirements or matters relating to a catchment, cultural matters. It requires you to consider things such as objectives, policies, and rules that are relevant to the management of freshwater and freshwater ecosystems in policy statements or regional plans. Any relevant freshwater matters that are identified in planning documents that are recognised by iwi authorities. So iwi management plans as an example, the national policy statement for freshwater management as well. And then where that comes together is in Regulation 10, it talks about the action plan. So one of the key deliverables of these farm plans is, firstly, you must identify the risks and the actions that's set out in Regulation 8. And then in Regulation 10, the action plan, the farm operator must set out an action plan. And within that action plan, they need to identify, for each of the risks and the actions that they've identified, they need to state, is that action that you're taking an existing action, or is it a new action, and how are you intending to undertake that over the next 5-year period? You're going to be required in doing that to categorise your actions within your action plans according to whether they are catchment actions. So if, for example, through an RPS or a land and water plan, or both of those documents, we've identified specific actions for a catchment, the farmer is going to be obligated through their farm plan to detail how they're dealing with that behind the farm gate in a way that's giving effect to the requirements at a catchment scale. The farmer must also categorise their actions that they're taking that are deemed to be regulated actions, and then also finally the supplementary actions. And so in that piece that I read out to you, hopefully that will become clearer in terms of those linkages. But it's that part there around Regulation 8 and Regulation 10 that, in my view, tie all of these bits together.
So the supplementary actions, and I see you've provided a definition of that from those regulations. But in a practical sense, what are those if they're not catchment actions or they're not regulated actions?
Yeah, so that's a question that I've been turning my mind to ever since the regulations came out, because I'm not convinced that the definition itself is overly helpful. But what I have taken supplementary actions to mean would be those things, as an example, such as good management practices that may not be regulated in plans, but which a farmer would be expected to undertake as part of doing the right thing in terms of the activity that they're undertaking. So that's how I would define what those supplementary actions are.
Look, thank you. And those are the only questions that I had, Scott. Thank you.
Thank you.
Thank you, Kate. Our final witness is Claire Perkins. Mine also.
Hi. Can you hear me fine?
Yes. Yes.
Perfect.
Would you take us through your summary and then respond to any questions?
Sure. So good afternoon. My name is Claire Perkins and I am a senior planner and planning team lead at Lampro. My expertise and experience are as set out in my primary brief of evidence. So that evidence covered the following key points: the consultation and engagement process, freshwater visions, a new resource use issue and consideration of this within the provisions, a transition framework with some new provisions, and some other minor changes that I included in my appendix 2. So I just briefly highlighted some of the key things that I thought valuable for your consideration. So namely freshwater visions. I maintain my view that the use of a region-wide objective in lieu of FMU, part FMU or catchment level visions is not consistent with clause 3.3 of the MPSFM. Ms. Boyd agrees in her section 42A report that a vision cannot be set at a region-wide level, but goes on to note that under section 62(1)(c) of the RMA, an RPS must include objectives sought to be achieved. She then concludes that for this reason, it is not a vision. However, in her opening statement yesterday, she notes that achieving this objective is part of the vision for each FMU. As highlighted in my evidence, other experts and farming witnesses, the separation of the visions back out to at least FMU level, even with repetition, will more effectively allow for future changes to the visions as needed at the FMU level or below. It will also provide for recognition of the diversity of catchments and provide guidance for implementation of other regulations, such as freshwater farm plans. Moving on to providing for resource use. I support the inclusion of a resource use issue as identified through the joint witness statements from the non-freshwater hearing. To ensure that this is followed through into objectives, I have recommended a new statement be added into the visions with some minor amendments to the policies, and referring back to my paragraph 48 of my evidence in chief there. I note that Ms. Boyd has, in attachment 1 to her opening statement, recommended rejecting my additional vision statement and use of the words primary production. She has instead recommended a minor change to LFFW 01A7 to add food production into this statement. If this were to be adopted by the panel instead of my recommendation, I would suggest that this be changed to food and fibre production to cover the full range of primary sector land uses, not just those responsible for food production. This better recognises the resource use issue. I also consider that B in my proposed provision should still be included as a key vision statement, which will ensure that the social, economic and cultural wellbeing of communities is enabled. This reflects the feedback from consultation and is supported by the farmer witnesses. I consider that this is a critical element to the visions that is missing at present. The new transition and process provisions. The need for an iterative process where the visions and timelines can be circled back to is essential, particularly in light of the lack of certain and available information on the degree of change for the visions to be achieved. I have put forward 2 process provisions that will allow for a transition, while also promoting the need to consider concurrent regulations and give priority to non-regulatory methods such as catchment groups where these may be as effective or more effective than additional rules in the future land and water plan. And the next page there, I've just copied in those 2 provisions for reference. Moving on to paragraph 11. In response to some of the points raised by Ms. Boyd in her opening statement regarding LFFW P7C, I do not consider that this provision constrains the decision-making process and limits the methods that can be used to only non-regulatory methods. Instead, it attempts to place focus on a preference to considering these methods where this will enable progress towards achieving the visions. I also accept that the RPS does not prevent staging from being considered in the land water plan process, but by including it in this provision, proper consideration must be given to this in order for the land and water plan to give effect to the RPS. Similarly, for E and F above in this provision, it may be appropriate to recognise that further regulation through rules is not needed where certain attribute states are achieved or declining trends are not being observed. Clauses E and F are not contradictory, as this provision is providing a list of matters which need to be considered, and poor water quality may equally be as much of a trigger for certain regulatory response as good water quality can avoid one. I have also recommended a new process provision to ensure that rural communities are actively engaged in the NOF process and development of the land and water plan. Since submission of my primary brief of evidence, ORC have advertised for expressions of interest for their first integrated catchment management working group in the Catlins FMU. The group will help deliver on the individual catchment action plan for the catchment, which will outline the long-term goals, the issues, identify possible causes and detail actions for addressing them. The expression of interest notes that the preference for membership is ideally mainly local people or those with connections to the catchment. I applaud this process and consider that it emphasises the importance of the engagement policy that I have proposed, which focuses on the need for engagement at the rohe or catchment level and engagement with local communities. It is more than a method of implementation, it is a process of engagement that will also enable establishment of visions at the catchment scale. I have therefore made one further edit to this provision in grey shading below to reflect the refinement of the catchment visions in the RPS that is likely to occur through the catchment action plan process and which is recognised through clause 3.152 of the MPSFM. And finally, minor tweaks to the other provisions. So I have recommended some other minor tweaks to the provisions throughout the freshwater planning instrument part of the RPS in my appendix 2 of my primary brief of evidence. I have read through but not yet had time to fully digest the changes recommended by Ms. Boyd's opening statement. I'm happy to discuss any questions that people may have on these.
Thank you, Ms. Briggs. The first questions come from Commissioner Sullivan.
Yeah, thank you. Nice to see you again.
Yes.
I just start off. Were you listening in this morning for the discussions that we had with farmer witnesses?
Yes, I have been.
Yeah, and I suppose we were, largely focusing in on the visions there, and I'm just wondering if you've got any amendments or comments from the questions that we had for them.
Yeah, look, I've been reflecting on that, and it's one of those really tricky ones. I don't envy the task you have ahead of you with needing to have put a recommendation forward as to what these visions need to look like in this version of the RPS, I guess. Look, I think the best we can do is to have provisions provided at that FMU level so that there is a simpler ability to come back and revisit them at that rohe catchment or even at the full FMU level down the track. That may be that whilst the land and water plan is being developed and the catchment action plan process is underway, more specific visions are established. I thinking to that Pomahaka Lower Clutha Rohe discussion this morning. The Lower Clutha Rohe obviously is quite broad with its with the area it covers and doesn't specifically address the nuances that you'd find in the likes of the Pomahaka catchment. So I think if you leave the vision at a catchment scale, at a region scale, sorry, you don't have the ability to come back and make amendments to the visions later that is as simple as changing what's relevant to that Rohe or that FMU. You've got just, you know, a standard applicable vision statement or objective statement, I suppose, rather than a vision at that region scale, and you can't tweak it as easily if you're dealing with catchment by catchment.
Yeah, no, thanks for that, because I suppose, you know, the issue that we've got, you know, for example, for the Pomahaka is if, you know, some over exuberant planners try and kind of implement it to the letter, they're going to be in a bit of trouble there potentially.
Absolutely, and I guess that's my key concern is obviously I tend to operate in that implementation area of planning more than the plan drafting area. So that's where I probably put that lens on it, is how would we be looking at this when assisting clients in this space of how that might be taken, or the conversations we then have to have with planning officers of the fact that this needs to be nuanced and reflect the diversity and the differences in different catchments, and having it simply at a region level doesn't necessarily allow that. I know it technically could allow it because it's got those words in there saying, you know, we're appropriate, but the reality of applying this on the ground often isn't that black and white to the planners dealing with it.
Yeah, and I think, you know, in terms of the Lower Clutha Rohe units, opportunities to restore the natural form and function of water bodies are promoted wherever possible. And I suppose you'd look at the Pomahaka and think, well, there's not a lot of opportunities there, or it's, you know, there's ways around it given the way the wording is. I mean,
yeah,
it's not.
Yeah, I'd agree. Like the words wherever possible, I guess, given out, but those words are often taken as the last case. The words, you know, like as an absolute backstop rather than actually reflecting the vision for that part of the catchment. And I just also want to point out, it just sort of came through possibly from some questions of those farmers this morning, that the wording of those visions isn't necessarily what I would recommend going forward as a whole, because I had sort of just made the comment off to the side, which, you know, was that actually I think these need to be fully extended back to the individual levels, and it was just kind of putting in there, well, if you don't agree with that, this is the absolute minimum that needs to be in there, but possibly some further consideration of them is required.
Okay, we thought you'd have done all the work for us. Well, we hope that you would. Yeah, disappointing.
I mean, I am reappearing again on Monday, so happy to put a little bit more time into trying to recraft them back to that individual level if that's of any assistance.
So, I mean, we've got them in the notified version anyway to refer back to.
They're there.
If we decide to head down that track. But I did have a couple of questions in evidence from Chief as well. Just find them. Yeah, just looking at P7A, policy 7A, LFW.
So paragraph 52.
That's the one.
Yep.
Probably don't need to worry about that one. Oh, hang on. Yeah. Yeah, okay, no, I think we've probably largely dealt with that.
I did make one note on that just in response to one of the Kaitahu comments yesterday with they're recommending the addition of use for mana whenua purposes in that list. My comment was that I didn't think this list was exhaustive. And if you included that and you were trying to include everything, then you'd probably have to go further and things like, water use or allocation for tourism purposes, for example. But my thought was that generally is sort of making sure you're including at least those three aspects, which were probably where the majority of water allocation goes rather than all of it.
Yeah, okay. Turning to the sort of your suggestions to enable the visions to be amended potentially through the land and water plan, and we've heard from the ORC council they don't think that that's lawful, and your council saying there's a way through there. I'm wondering how you're envisaging that would work. We'd still have if we put the wording in, say that you're suggesting at your paragraph 64, where you say unless amended through land and water plan in accordance with LFFW 7B, and you've got that 7B in here. I mean, I suppose if somebody's coming along, it's amended through the land and water plan, that would be presumably recorded as an updated vision in the water plan, would you be thinking?
Yeah, I guess it sort of comes back to where Ms. Boyd was noting that the visions will be, further fleshed out through the land and water plan, and there's the ability to kind of like go further with them, I guess, recognising we still have to have visions actually in the RPS in line with the MPS. Yeah, I kind of saw it that there could be a reference to saying, for these specifics, or it could be taking the Pomahaka, for example, that there is a recognition that for that particular part of the Lower Clutha, that one needs to be longer or different or something. So look, I don't think it's necessarily perfect yet what that wording is, but I think it's the idea that it would be a simple approach to be able to say that, through the land and water plan process, which is, underway as we speak at the moment, that could have identified some further detail of those visions and further timeframes that are needed to be ambitious and still reasonable. But also accepting that you could follow a Schedule 1 process and amend the RPS at the same time that the land and water plan process is going through if more detail has become available. I am conscious that the land and water plan is, as I understand it, due to be released as a draft for consultation in another 6 to 8 weeks' time. So, we're not actually talking about a huge time frame for that level of information starting to come through, which is also slightly concerning in terms of the needing to have a lot more information for a land and water plan drafting. And if we don't have it now, is that going to be available for that or not? Yeah. But that's not really probably for your questions now.
No, but I suppose I wonder if there's going to be end up being some uncertainty there, though, given you'd have a vision in a regional policy statement, and then you'd have something recorded somehow in the land and water plan, and how would you necessarily know where to go to? And I wonder if there's an opportunity in the land and water plan to be more specific for certain areas anyway, and given that the NOF process directs to sort of look at the values for the FMUs and then work through that whole process, is that going to achieve what you're wanting in terms of drilling down into those visions and I suppose being able to express them in more detail? Is that provided through the NOF process anyway?
I mean, I guess it is, but the concern for me is that you've got dates set hard and fast in the RPS at present, or will be, and if there's no reference to the fact that these can be revisited or may need to be revisited, then there's in all likelihood, the land and water plan will say, well, those dates are set, so that's what we must follow. And there's no guarantee that there'll be recognition that it may need to be revisited.
And do you acknowledge that while we've got dates set, we've also got slightly fluffy wording on the visions that, that do have things like where possible and practical practicable and various other sort of phrases in there that do provide those sort of outs. You know, it's not, you know, that you must meet a nitrate concentration in the receiving environment by each state. You know, it's not quantifiable in that way.
Yeah, no, I accept that they are still quite open to interpretation. It's just more that we just have a lot that we don't know yet as to what the implications are for trying to achieve those visions. There's just so much unknown in terms of what change is required, how significant that is, and how that could be achieved, that there's still a risk, I think. And I think I made reference to Mr. Cardina's evidence with regards, he'd done some evaluation of the timeframes that may be required to attempt to achieve those goals in the dairy sector. And there could be quite substantial change required, but we still just don't have that clarity to know. And I guess that's just where I was trying to cover off that uncertainty at the moment.
Yeah, no, we've got that as well. I'll just see. I'm just checking my other questions in here, whether we may well have covered them off. Yeah, no, I think we've covered off the other questions that I've got in my evidence here. Thanks, Claire.
Well, thank you.
Yeah, thank you. Commissioner Sutherland's kind of dealt with the vision sort of questions that I had as well. So just sort of focusing, Mr. Perkins, on your, I guess, your process policies. And when I read them, I probably sort of had the same thoughts that Ms. Boyd had, to be fair. I'm not sure if you've read her opening statement. But in terms of policy P7B, it just occurred to me, well, what is the value in that when you have to probably do those things anyway? It's sort of a Section 32 analysis. Leaving aside the time frame thing, because we've discussed that, but those other matters, what is the value of that in this particular document?
I guess where I was trying to go here was that, I mean, if I look at the Section 32 analysis that's been done now, whilst it's a requirement to do that, it's been somewhat absent the actual assessment of what changes are required, you know, what is the reality of us being able to implement that and achieve that. So my intention here was really to try and highlight that those things must be done. It's not something that can be kind of glossed over, which I often, just from the few plan processes that I've been involved with, I do feel like the Section 32 report that's often gets glossed over some of those aspects. And it just felt like it is a bit more weight and it has to be given a lot more due attention if it is included as a policy of those matters that must be addressed.
Yeah, okay. Well, I guess you do have the ability to challenge the Section 32. You're not doing that so much.
No, I mean, I have pointed out that it's been somewhat absent, and I think some colleagues of mine have pointed that out in the non-freshwater part of the RPS process as well. I mean, we can't change that. What we've got here, we've sort of highlighted that it's not valuable to kind of keep going back on it. The information isn't there to support that at the moment. So I don't think it's going to help the process to just argue the Section 32 hasn't been sufficient any further, and more that we actually make sure that those matters are properly considered during the land and water plan drafting, in terms of the fact that the rural sector is going to be the one that has to make the most change to achieve these visions. And so the timeframes and the transition and what's needed to happen must be properly considered.
Okay, thank you. And the next one, P7C, non-regulatory measures that Ms. Scott's touched on as well. In D, we've heard a lot about catchment groups. Mr. Aspinall sort of indicated, well, he was probably not quite as positive about them being used as a sort of a mandatory tool, if you like, simply because they don't work that way. They got to have buy-in, and that's how they'll achieve things. So, what do you mean by leveraging in this context? And how would you see that come through into an implementation method?
Yeah, look, I know that that word isn't probably terribly helpful in terms of having the clarity at the moment, but I guess the intention behind this policy, which I tried to sort of just highlight in my summary today, is that consideration of these matters and how they might influence the regulations that do or don't land in the land and water plan is where we were getting to. I was sort of getting to, and recognizing that I've kind of put the word existing catchment groups in there because they tend to be the ones that are the proactive ones. You're not forcing catchment groups to be set up for every catchment or subset of a catchment through the land and water plan process necessarily, but looking to, for the example of Mr. Aspinall's situation, you know, what is going on in these catchment groups that could be brought through non-regulatory methods or brought through some way in terms of the method of implementation that you use in the land and water plan. So it's just sort of saying how much, what can we take from that, or can we rely on them in some areas or not?
Yeah, okay, it's just one of the many tools in the toolkit. Yeah, I guess that sort of leads into E as well. I guess that flows out of that catchment thing where water quality is already at a target attribute state. Around that, and I think Ms. Boyd again highlighted, well, what happens when it starts degrading, and she noted that clause 320, I think it is, of the NPS actually deals with that. I kind of read your F as to be sort of the trigger that may kick in if E catchments in that would fall under E start to deteriorate. Is that how that's meant to work?
Yeah, I mean, I guess they're not sort of sitting there as one then the next. They're part of this list of methods to consider, and it may be that you say, like if I think of the Upper Lakes where I'm sitting at the moment, there is really good water quality, and it may be that if there was no trend of decline, that staying at the attribute state means there's less intervention required. But you could equally, a trigger point could be a trigger decline. It doesn't have to be necessarily a set. It could be that if a decline is observed over a set period of time, for example, that could mean that steps need to be taken. So I don't obviously have the answers for what those are because it's not the land and water plan, but it was more wanting to make sure that those different types of options are considered.
Yeah. When water quality is good in the catchment, why would new regulatory requirements be put in place anyway? Is that a possibility you see happening through this?
Yes, I guess it is. It depends on if there's sort of region-wide rules put in place that say, you know, any farm over X area has to get a consent. You know, there could be something as simple as that, that may not necessarily be appropriate or properly taking into consideration the different values and the different visions in the subcatchments.
Yeah, so that's where I was leading with that. That sort of drives your approach to let's get rid of that overall vision and get back to catchment specific or FMU specific visions.
Yes, yeah.
Yeah. Yeah, I was also interested in that. I was expecting to see from you like what jumps out in that Pomahaka catchment is the modification that's taking place in those waterways and the issues that has. I'm trying to understand how that could be if we were of a mind to go down that track. How would you express that in the vision to deal with that concern?
Yeah, look, and that's, I think, with the challenges that we've got the information about that one subcatchment now because we have some really sort of motivated farmers who have been doing some work in that space. But if but we don't have that information about every catchment, and it's quite possible that, and it is very highly likely that there's other situations and other catchments like the Pomahaka that sit within current FMUs or rohays that need to have some more specific vision statements, because they just simply, by applying one vision statement at that full FMU level even, isn't going to be appropriate. So I don't know that on the spot today I have an answer for how you could deal with the sedimentation issue specifically for the Pomahaka in that Lower Clutha FMU, but I can happily put my mind to that and come back on Monday with the beef and lamb team and see if I've got some sort of suggestion for you.
Well, that might be useful, because the other one that has, don't want to mention its name because it's always the one that raises the most controversy, but the Manuhera Kia, the evidence of the engineers that we had for the non-freshwater was quite significant around how that catchment has been modified and what happens in that. I would have thought there's an opportunity there as well to have some vision around that. Again, how you express it and articulate it, I'm not sure, but these are the areas that are modified where some of the aspirations really, it's hard to see how they'll actually be achieved. And unless we have some guidance around that, we can't do much about it.
Yeah, look, I fully agree that there is definitely some specific differences in some areas that are really easy to pick off the top of our head now. And happy to have a think about how we might be able to address that through the current visions as they kind of were notified or slightly tweaked through evidence so far.
Yeah, I guess that was a question I did have, was around is there enough nuance in the notified versions or the things coming through and submissions to actually deal with those more specific issues? But again, we might leave that for you to address on Monday.
Thanks. But yeah, I mean, just briefly, it is going to be tricky. I don't know that we're going to have perfect visions, even if we pull them back into the FMUs as they were notified, because I mean, not being personally, responsible for the consultation and understanding the specifics that came out of that process so far, I sort of highlighted through some of my comments in my original brief of evidence that it does appear from my reading of the consultation summary and my conversations with different farmers that there is differences in the way that resource use and other things should be prioritised in different catchments that doesn't seem to have come through, and definitely doesn't come through at a region-wide objective level. And it may be that we have to revisit them through the land and water plan and catchment group processes, that we can then, it may be a review of those visions in the RPS rather than a link to them in a land and water plan. It might have to come back to that level.
Okay, well, thank you very much for your thought-provoking evidence.
Thank you.
I didn't know if you could.
I've only really got a couple of matters. Everything else has been canvassed. But I must say that when I looked at your 7D and your suggestion at the end that there be amendments through the land and water plan to the RPS timelines, I wondered what was gained by that, and that either way, you're going to have to do a first schedule process.
Well, I guess it's whether or not you're needing to amend the RPS as a whole, or whether you rely on the land and water plan to process the Schedule 1 process that will be followed to put those dates in there. I had been reflecting after the conversation around this and Ms. Boyd's comments and things on it yesterday. And, obviously some, you heard from Ms. Irving this morning that from a legal perspective, it could still happen. But you could equally run an RPS Schedule 1 process alongside that land and water plan to change those visions. It's just a matter of if we actually have all that information in the next 9 months to say what those changed timelines should be, or will it be something that comes staged over time and then we end up having lots of Schedule 1 processes every 6 to 12 months for different catchments or different FMUs. I'm not quite clear on exactly the timelines and what level of information is actually going to come through the land and water plan and what is not that far away.
And just looking at your suggested paragraph 77, your suggested LFW P7C, the in subclause A, it concludes, so the implementation of new regulation can be managed by resource users. Are you meaning economically managed?
Yes, I guess there really probably was an economic focus to that, and that's I think I made some comments earlier as well. For example, the Plan Change 8 process for dairy farmers having to invest in significant capital expenditure, that process has just started. They won't be able to put everything in at once, so it's more of that transition, and I guess it's provided for with long timeframes for those visions to be achieved, and that there will need to be some staging, and it may be some staging of regulations as well, not just the vision. And although Alan Kubert's asked you about it, but that subclause D, the leveraging, when I read that, I had written in myself to try and make sense of it, but I needed to just bounce it off you to see whether it was what you were meaning. Were you meaning leveraging actions taken by the existing catchment groups, or were you meaning to actually try and in some way have an influence on the actual method of operation of the catchment groups themselves? Yes, it definitely would be leveraging the actions, but I think it's also leveraging the groups themselves to be able to make change and implement change as a collective. So it's, I mean, I guess that does come back to it being the actions that they can take at a catchment group level and sort of non-regulatory path through that than just through rules.
Well, those were the only matters that I needed to have clarified. So thank you, Ms. Perkins, and your evidence is certainly helpful in terms of trying to address these vision issues. Thank you.
Thank you.
How are we going?
We're good. That is all of our witnesses. Just one matter which I didn't touch on in my opening submissions related to a comment from Ms. Boyd about transition provisions, and I think she indicated that she was still had an open mind about a utility or something along those lines. And it just occurred to me that that might be something that could benefit from planning witnesses discussing, that if a transition provision was to be something you think is useful, having something that the various planners have discussed and worked through together. And so whether there might be some utility on conferencing or something of that sort on that topic. And just to flag that certainly our clients would be interested in participating in that, because I think fundamentally for our people, the transition process lies at the heart of the concerns. In some ways, almost anything can be achieved given an appropriate time frame and implementation pathway for that. So that would go a long way to addressing their concerns. And I'm sure that just about every party recognises the need for a transition to be managed carefully so that our communities are sustained. So if there's something we can agree on, I would hope it was that.
Thank you, Ms. Herbert.
Thank you.
So we've reached the stage of the day, Mr.
Yeah.
Thank you, Mr. McKellar, and thank you for fitting in with the rearranged time slots.
Good afternoon. Thank you for setting up the time this afternoon. My name is Gavin McCullough. I'm a principal planner employed by Foresight Consulting Limited. I'm attending today on behalf of fuel companies to assist the panel on matters within my planning expertise. My evidence addresses the following provisions, which are the subject of this hearing stream: policies LF-FWP7 and LF-FWP7A, and policy LF-FWP15. I understand my evidence is to be taken as read, and I will not repeat it. I'll be pleased to answer any questions in relation to it. Policies LF-FWP7 freshwater and LF-FWP7A water allocation and use. I intend to speak on today on the matter of the inclusion of temporary construction dewatering and discharges in the proposed new policy LF-FWP7A water allocation and use. I agree with the change proposed in the section 42A report to create a new policy LF-FWP7A water allocation and use.
Just like stop you a moment. I think we've possibly lost.
Yeah.
We're
missing a page.
We're missing a page. Your evidence. All we've got is 2 paragraphs.
Only got
I was going
last
to congratulate you on being very
We
brief.
were excited. We're missing a page. From
Maybe it was meant to be double-sided.
It was meant to be double-sided. Yes, my apologies for that. Spare one that can be photocopied. Thank you.
the Jeff might have it there now.
Yeah, I was going to congratulate you on a 2-paragraph summary. That was
Not quite that great.
But it didn't mean that you'd given up on some of your changes. I thought it was.
yeah.
Quickly print you off some new ones.
Thanks.
It's interesting. I've seen the next one.
You're still employed, but
Definitely on a weekly basis and reminding.
right, yeah.
On High Street.
We had a hearing from vendors
George Street, yeah.
a couple of weeks ago on senior degrees days.
I like
The gate. There was no equipment.
I like that. I've eaten it quite a bit, but.
So near that training off in front of you, you go up a little bit further. It's training off
Well, she went overseas for a while. She did a surprise. Skydiver. Skydiver.
Because back then, they were
What time we jumped out of the plane and they said, gosh, we landed it. I think it did. Yeah. I was thinking for a while.
I was going to say which one was
ABC was been for quite a while.
I just can't learn how to do 30 pages.
It's interesting because
Maybe she was just pissed like she was allowed to film this. Yeah.
you get off. You get off.
Probably just reach it. It would have been done by then.
We'll get the message loud and clear on the last page.
But it is pretty, I mean, it's not.
Yeah, there's no.
So this is sort of the main.
Yeah.
And then
Used a full disclosure to every single measure. Don't really hear from this. The law's the law. Go on. Oh, very briefly. We didn't, yeah. It was, I think it was set down for 2 days. And I'm not finished after that.
yes, we've got you.
No worries.
This one's no good now.
Anything up now about
No.
Thank you. My apologies for that. Okay, so.
Paragraph 3.
Paragraph 3, beginning with the policies P7 freshwater and P7A water allocation and use. I intend today to speak on the matter of the inclusion of temporary construction, dewatering and discharges in the proposed new policy LFFW P7A water allocation and use. I agree with the change proposed in section 42A report to create a new policy, FWP7A water allocation and use, provide more direction on allocative and technical efficiency, as well as the benefits of using water. I originally proposed that policy FWP7 be amended to ensure that the avoidance direction does not lead to prohibited pathways for essential temporary construction dewatering takes necessary to facilitate operation, maintenance, upgrade and development of infrastructure and over-allocated catchments. As outlined in my evidence, dewatering for construction and maintenance purposes, whether for the activities of the fuel companies, e.g. the installation of underground fuel tanks, or for other construction activities, is a temporary activity. For practical construction reasons, all measures are taken to require as little dewatering as possible. And the water pumped from a construction site is typically discharged to a reticulated stormwater network, where circumstances dictate in one of the other ways identified in my evidence. I agree with the section 42A author that the use of avoid in FWP7 is consistent with the NPSFM, and that the regional policy statement freshwater planning instrument must also be consistent. I agree that the management of specific activities is more a matter for regional plans. So I note that the proposed policy LFFWP7A now identifies classes of activities and applies direction to the way those classes of activities are treated. I believe that the inclusion of temporary dewatering activities as specified in my evidence is consistent with this approach and is currently addressed this way in the partially operative regional policy statement 2019 in policy 313C3. Additionally, I recommended the addition to clause 2 of FWP7A the following: any associated discharge occurs as close as practicable to the point of abstraction, in particular to surface waters hydrologically connected to the source of groundwater. The second point that I wish to make was in relation to LFFWP15, stormwater discharges. I strongly support the recommendation of the section 42A author to separate stormwater from other discharges into separate policies. I agree with the inclusion of clause 4 promoting source control of stormwater discharges. I note the section 42A author's request for clarification of the reference to industry-led guidelines in this policy. I believe the new LFFWP15 should include the proposed clause 5, promoting the use of relevant industry-led guidelines for the management of stormwater, as providing the basis for the reference to industry-led guidelines in the method LFVM3, community involvement. And I believe this wording is consistent with the wording used in clause 4 of policy 15 and is therefore equally clear in its intent and application. I'm happy to answer any questions you may have on this or my original evidence.
Thank you. Thank you, Colour. Any questions?
Yes, but just one question. And I'm assuming that you do some work for the fuel companies in regions outside Otago as well. Yeah. How's this dealt with elsewhere, where there are allocation limits, I suppose, and reasonably black and white provisions around, you're in trouble if you're over the allocation limit with difficulty?
As my understanding from, so I haven't dealt directly with those, other people I work with have and provided me with advice on that. With some difficulty. It makes the application and consenting process much longer than it need be for the action being undertaken.
Yeah, because I know in some plans there are sort of more lenient rules for dewatering. And I presume that would be something that you'd be wanting to see in the land and water plan.
Yes, so that it's clear that it's a activity that can take place.
Yeah. And I'm just assuming that you must be thinking that that's going to be that for those temporary situations, that is going to be consistent with, well, what policy is it? Policy 11, isn't it, of the MPSFM? You'd be saying that that's fine, I presume.
Well, again, it's arguing that it's not so much a use as a movement of water from the dewatering site to the nearest water body or to the reticulated stormwater network. It's not a consumptive use.
Yeah, okay. Yeah, that's fine. Thanks.
No, I have no questions. It is very clear what you have to think.
I have no questions.
And similarly, so thank you very much.
All right, thank you, and sorry about the earlier delay.
That's right. Concludes the day.
Nothing.